Good afternoon. I'd like to call this meeting of the Woburn License Commission to order at 1:05. My name is Tommy Skeffington. I'm the chairman. To my left is Commissioner Gilgun. To my right is Commissioner McGrath. Our clerk is Gordon Vincent. Our liaison to the Woburn Police Department is Captain Murphy. Also in attendance, the City of Woburn is Attorney Mark Dickinson, Attorney Salvati, and is the Chief? And Chief Ferrulo. Chief Rufo, sorry. Sorry, buddy. So first, just to start it off, we're here for actually two revocation hearings. The first being for the doghouse for 204 CMR 2.05, permitting an illegality on a licensed premises. Woburn License Commission Rules and Regulations, Section H 14, and the Woburn License Commission Rules and Regulations, Section 1126. With that being said, I believe that back in December, we had taken a vote to not renew the licenses for the doghouse, and probably wrongfully so. And we're here today to grant the owners and their representatives a impartial hearing, which is your right. And right now I'll turn it over to Attorney Dickinson.
Thank you, Commissioners. Mark Dickinson, representing the...
Can you speak into the mic?
Absolutely.
Please. Anyone that comes up, speak into the mic. And then once Attorney Dickinson's done, we'll go over the parameters of how we want to hold the hearing. Okay?
Good morning, Commissioner. Good afternoon, Commissioners. Mark Dickinson for the Captain John Murphy as his capacity as liaison. I'm essentially representing the police department as prosecutors in this violation hearing. What I would like to bring to the Commissioner's attention is that there have been several motions brought by the Council for the Licensee.
Can you pick the mic up a little bit?
Sure. There's been several motions filed by the Council for the Licensee. Attorney William Kelly is representing the licensee. I understand that there are two hearings on for this afternoon. One concerning the license of the Doghouse Bar and Grill, the other regarding the license of the Taste of Brazil, Tudo na Brasa LLC. I would suggest at the outset, and I'll let Attorney Kelly comment on this, that we consolidate both hearings for the ease of administration today. And so I would move the Commission that we consolidate both hearings to occur simultaneously, since I believe the licensees and all their witnesses are here. And then I would suggest next, after you consider that you then take up the various motions, including the motion to disqualify this License Commission from holding the hearings today, as well as the motions to dismiss that have been filed. So because the motions to recuse you and to dismiss are advocated for Mr. Kelly, I'll let him speak to those, but I would first raise the question of whether we could consolidate the hearings to have them both occur simultaneously starting now. Attorney Kelly.
To make a motion? To consolidate?
Yeah, I'm making a motion to consolidate. I want to see, I give the opportunity for Attorney Kelly to talk now.
I just want to make...
Just come up to the microphone so we can hear you. Can't hear you from... Speak nice and loud into the mics, please.
Good afternoon, Mr. Chairman, Commissioner Gilgun, Commissioner McGrath. I am Attorney Bill Kelly, and I represent both licensees. Identified by Attorney Dickinson, the Doghouse Bar and Grill, LLC, and Taste of Brazil Tudo na Brasa LLC. Yes, I will, well, first, I want to thank the commission for your consideration in setting this date in light of my personal demands, so that I am able to be here physically and give you the respect and advocate for my client the way that everyone deserves. Second, as I counted the motions that were filed, because they were, and they still are right now, two separate hearings, I had to file motions in each case because they had not been consolidated up until now. So I understand Attorney Dickerson has orally moved to consolidate those hearings. All I would ask is a brief moment of 3 minutes so I can confer with my client to discuss that with him and return right away, subject to your discretion.
Absolutely.
Make a motion?
I make a motion to allow Attorney Kelly to speak with his client.
Second.
Motion made and second. All those in favor? Aye. All opposed? Ayes have it, 3-0.
Thank you.
Feel free.
I will use all haste.
Okay.
Thank you.
That was fast.
Said I'd be as fast as I could.
Floor is yours.
Oh, thank you. Thank you for recognizing me, Mr. Chairman. After consultation with my client, we will agree to the oral motion to consolidate these two hearings into a single hearing for purposes of economy of administrative time of the commission as well as the parties.
I make a motion to consolidate the hearings today.
Second.
Motion made and seconded. All those in favor?
Aye.
Aye. All those opposed? Ayes have it, 3-0. Thank you.
Need anything else from me right now?
You're talking to the mic.
Do you need anything else from me right now? I'll step back.
I think we're good.
Commissioners, good afternoon again. Mark Dickerson for the liaison. I would say that the next thing, before we proceed to the actual hearing on the violations, that you need to first consider the motions of the doghouse and as well as the Taste of Brazil to disqualify each of you. Because I would suggest that if you were to allow the motion to disqualify, then we would need to postpone the hearing date, and you would then need to assign a special hearing officer or officers to do that. So the first, I would suggest that that you would allow Mr. Kelly to briefly give his oral argument as to why you should be each disqualified, and then I'll oppose that. So I would suggest that that's how we proceed next.
Yep. Make a motion to allow Attorney Kelly to give his.
Motion made and seconded. All those in favor?
Aye.
All those opposed? Ayes have it, 3-0. Mr. Kelly, pull that mic up nice and.
Thank you,
all of us
Mr.
are- Yeah.
Steal Mark's notes and I'll loose leaf binder while I'm here. Thank you, Mr. Chairman. I'll proceed in order that they got filed, which is first the motion regarding you, Mr. Chair, as well as then I'll proceed to Commissioner Gilgun, then I'll proceed to Commissioner McGrath. You have 6 separate motions to disqualify or recuse. 3 from the doghouse, 1 for each member of the commission, and 3 additional from Taste of Brazil, again, 1 for each of the 3 members of the commission. The basis, the foundation, indeed, I respectfully submit the need for these motions to be filed are the unique procedural events that occurred back in December of 2024. In that December 2024, as the chair referenced, the commission took a vote to deny the renewal application filed by both the doghouse and separately by the Taste of the Brazil. And for the purposes of a clear record, when I refer to the doghouse, that is the license holder, the Doghouse Bar and Grill LLC. When I refer to Taste of Brazil, I'm referring to the second license holder, Taste of Brazil - Tudo na Brazza LLC. What was significant and of great legal impact, I submit, is the fact that at that December 2024 meeting, neither the doghouse nor Taste of Brazil were posted on the legally required agenda. There was also no prior notice to the doghouse. There was no prior notice to the Taste of Brazil that the commission would be considering denying the timely filed renewal application, which under the alcohol laws, as you well know, entitles them to automatic renewal as long as they filed during the month of November, which they did. Despite that, the commission proceeded to take a vote without a hearing, without notice to the license holders, without any evidence being proffered to you in proper form, that is, under oath, on which you can legally base your decision. When you committed that substantial legal error, a number of legal consequences fell from that. First, and perhaps looming large, is that you have denied the doghouse and the Taste of Brazil their clearly established constitutional rights to due process. When you're thinking of taking away from them a license that is required for them to conduct their business and hire people here in the city of Woburn and be, I suggest, an economic engine in the middle of the downtown on Main Street. When you did that, the only thing the doghouse and Taste of Brazil could do is what they did. First, file an appeal from your action to the ABCC. And an appeal hearing was scheduled, as you well know. Second, in order to preserve the status quo, both the doghouse and the Taste of Brazil were compelled to file an action in Middlesex Superior Court seeking a court order against the commission enforcing its unlawful decision because it was based on unlawful procedure without required notice and without any form of appropriate evidence. That basically put poison into the well water for the entirety. To your credit, you did, after consultation with the city solicitor, reconsider and reverse your decision denying the renewal. You renewed it, you issued the licenses, the Superior Court proceeding was dismissed, and the ABCC appeal was dismissed. Yet, you still were muddied, for lack of a better term, by your unlawful process and your unlawful decision. So until today, which is the first date we've had a hearing scheduled in front of the commission, you remain sullied by that unlawful action in December of 2024. The December 2024 meeting is the subject of minutes that have any number of facts that clearly establish the wrongdoing committed by the 3 members of the commission at that meeting, that fairly and reasonably show that you have a bias or a prejudice by which you cannot give either the doghouse or the Taste of Brazil the fair hearing that is required under the Massachusetts alcohol laws, the Massachusetts statutes, and indeed the constitutions of both the United States and the Commonwealth of Massachusetts. Accordingly, this motion to disqualify was submitted on behalf of both the doghouse and the Taste of Brazil. While the level of communication and interaction varied with the different members of the commission, and indeed the chair, as is your responsibility that comes with the position, was the most vocal, the most active, as borne out by both the minutes and the video of that meeting. It still does not excuse, justify, or cleanse the wrongdoing and the illegal action and decision that was made. Accordingly, I bring these points of highlight, and as well as without waiving any of the additional points in the motion, either the facts or the law that support this request. As you read through that motion, you will see that there is clearly established the constitutional right to a fair and impartial, independent fact finder to give Doghouse and Taste of Brazil the fair hearing and the full measure of due process to which they are entitled. Next, in regards to the motion for Commissioner, so in the motion, there is a discussion of the legal standard that applies anytime the bias and prejudice and impartiality of a fact finder is challenged. There is much case law that discusses this as applied to members of the judiciary and the judicial branch, but the constitutional protections apply just as much, if not more, in the executive branch for administrative officials like the Woburn License Commission, like any local licensing authority under Chapter 138, and indeed like the ABCC. It is a two-part analysis that each of you must undertake. The first, as discussed more accurately in the motion, you must each search your individual consciences to determine whether you actually do hold a prejudice or a bias that eliminates your impartiality. And if, hypothetically, for the sake of argument, you conduct that internal examination, subjective examination, and say, no, I think I'm all set, your job's not done. You have to continue now and conduct an analysis whether there is a reasonable basis based on the totality of the circumstances, whether a reasonable member of the public can question your impartiality, or whether you have manifested in an unlawful open public meeting a bias or prejudice against the Doghouse and the Taste of Brazil. I suggest that given the video, given the minutes, and given the documents, it's clear you should not be hearing this case. It continued with the January 2025 meeting, when there was a reference, I believe, by the chair to a 50-page report that had been submitted to the commission by Captain Murphy. The chair, if my memory is right, at the January 2025 meeting, if it wasn't there, it was at the December 2024 meeting, urged each member to read that report. That creates a separate independent legal issue, because that is an ex parte communication within the textbook definition of that term that law students learn the first year in law school. You cannot have direct communications with a fact finder about a particular issue when there's no notice of a hearing that's issued and when there is no notice and an opportunity to be heard by the other side. You cannot take secret communications. You cannot take just one side of the story without having an opportunity to hear from the other side at the same time. The totality of these circumstances muddy each member of this commission. Perhaps unintentionally, but it doesn't have to be intentional. The legal significance comes when it happened, and there's no mistake. There's no dispute. This happened. And so the motion asks for you each to step down from hearing this hearing and acknowledge, and I will say purge, because I think that's the right word, the illegal processes and the legal mistakes that have taken place beforehand. There's, a separate motion for Commissioner Gogun, two of them, one from Doghouse, one from Taste of Brazil. And the basis is essentially the same. It is the result of the illegal, unagended, in violation of the open meeting law, no notice to the Doghouse, no notice to the Taste of Brazil, no evidence under oath or any other competent evidence. And yet, you made a decision adverse that put the Doghouse and the Taste of Brazil out of business for 17 days. You took that away from them, contrary to law. Now, you corrected it, but no one has yet remedied or made them whole for the 17 days they were shut solely, substantially, and proximately caused by your unlawful decision. And again, with the motions for Commissioner Gogun, we do not waive any arguments that are contained in the body of the motion, either factually or legally. And last, but by no means least.
Would you repeat that, please?
I'm sorry?
The last couple of sentences.
I am not waiving the fact that I featured highlights during my oral presentation to you just now are highlights, and it's not intended to waive any of the facts or the legal principles that are more fully argued in the written motion. In regards to the third motion regarding Commissioner McGrath, again, the core issues are the same. The action in December of 2024 in which he fully participated that violated the open meeting law wasn't on the agenda. No notice to the Doghouse. No notice to the Taste of Brazil. No evidence in a competent form on which you could base a legally sustainable decision. And it continued into January. And again, I do not waive the facts or the law and points advanced in the written motion, but just trying to touch the highlights. So based on that, the motions are seeking for each member of the commission to conduct that two-part analysis. First, the subjective examination of your conscience, and second, stepping outside yourself and asking, what would a reasonable person believe? I would be happy to answer any questions any member of the commission may have, subject to the discretion of the chair.
Questions?
What's that?
Questions?
What's that?
Do you have any questions?
I do not.
Attorney?
Good afternoon again, Commissioners. Mark Dickinson for the liaison, and we oppose the motion to disqualify yourselves. Let me keep it very brief. There were the substance and the main allegation raised in the motion has to do with the fact that this board, this commission, in December addressed the renewal issue, admittedly incorrectly. And that seems to be the gist of that because you handled the renewal of these licenses previously, and there was a 17-day loss of operation of the business. They're saying there was a due process issue, their constitutional rights were harmed, and therefore, bless you.
Thank you.
Therefore, you are now obligated to disqualify yourselves and essentially continue this hearing. There's at least 3 reasons why you should not. First of all, you remedied the issue by having the main argument was that they lost their due process rights to defend their licenses. Well, you remedied that by reinstating the licenses and then having this public hearing today, which has been noticed since at least March 5th, and they've had ample opportunity to prepare a defense. They've had their witnesses here today, and there's no reason why you should not give them that full and fair hearing today. And the only reason would be if any or each of you thought that you personally had a conflict of interest or were somehow biased and could not act fairly and impartially with an open mind to the evidence you're about to hear this afternoon. I would suggest that what each of you should do in 2 other points. One is that this motion to disqualify you is also untimely, and essentially they waived their right to bring this motion because this is an issue. Had they known that licensees were going to seek to disqualify you, then instead of asking for a month-long continuance of these proceedings, they should have immediately raised the issue where you could have considered the timing, and you could have considered in a more your leisure as to whether you want to have others be hearing officers for this case. And so my first point would be that this motion is untimely brought, and with all due respect, I think it's brought to just delay these proceedings and kick the can down the road. The second point is one I already made, which is the due process concerns that they raised have already been remedied. You are now giving them the full hearing. And the third point I would raise is that as public officers, you are presumed to have a presumption of honesty and integrity and not bias. And they have to come forward with some specific fact as to whether each of you has a personal stake in the outcome or has otherwise is unfit to hear this. And just because in the prior renewal process you may have made a mistake, or maybe you've made a statement about the fact that there has been a very public federal prosecution and you might have read some of those papers, it doesn't mean that you are necessarily disqualified. All it means, and I would suggest that the next step for each of you is to state on the record today if you are able to, with your own conscience, fairly and without bias, proceed with the hearing today, then you should so do so. And if the vote were to be, for instance, if 2 of you thought you did need to disqualify yourselves, then obviously we would respect that and we'd adjourn today's hearing, and you would need to then appoint a special hearing officer. So with that, I would suggest that you should each go on the record and state whether you have, consider whether you are biased or able to sit here with an open mind today. And if you can so state that, then you should deny the motion and move forward with the next sets of motions.
Motion, David? Do you want the record?
Well, I think
I am very confident in telling everyone at this hearing that I have read this material without prejudice, and I'm confident that I can go on and make a just decision at this hearing.
my record shows from the past that I've never been, anything but straight with Hugo or the Doghouse or the Taste of Brazil. And I have no prejudice here at all.
I concur with both. I have no prejudice against either the Doghouse or the True to Brazil, and feel as though I can make an impartial decision after hearing all the evidence that will be presented in front of us today.
I make a motion to deny, each motion to recuse.
Motion's made to deny
Second.
and seconded by David. All those in favor?
Aye.
Aye. All those opposed? Ayes have it, 3-0.
Commissioners, I would suggest, Mark Dickinson again for the liaison, I would suggest that now you should proceed with, there's two motions to dismiss. One is a motion based on the principle of res judicata, that you already decided this case. I'll let Mr. Kelly make that argument. And he's got a second motion based on the motion to dismiss, based essentially on the statute of limitations, that the notice violation hearing here alleges that and we will be presenting evidence of conduct that's occurred as far back as 2016. And so I believe Mr. Kelly wants to present those two motions, and I would commend that you address those two motions to dismiss before we proceed to the public hearing as well.
Motion to allow Mr. Kelly to speak at this hearing.
Second.
Motion made and second. All those in favor? Aye. All those opposed? Ayes have it, 3-0. So we now go into the hearing phase, correct?
I would respectfully suggest you let Mr. Kelly argue his two motions to dismiss. I think it's
Okay, yeah, I didn't see him
four,
getting up.
four
that's why.
motions in all, but I'll defer to Mr. Kelly to make his arguments.
You have the
Kelly?
floor, Mr. Kelly.
Thank you, Mr. Chairman and members of the commission. What you have before you now for consideration is the first motion to dismiss of the doghouse and the first motion to dismiss of the Taste of Brazil. As before, when I reference doghouse, I mean the Doghouse Bar and Grill LLC. When I reference Taste of Brazil, I mean I'm referring to Taste of Brazil - Tudo de Brasa LLC. Tudo na Brasa, I'm sorry. And the motion to dismiss here is based upon res judicata and issue preclusion, two close principles of law that basically say, once you have a matter, an issue, that has been the subject of an official determination, you are not free to go back and revisit that. That the parties to that prior decision are bound by that decision. Here, we have a renewal decision that in December of 2024 was wrong and illegal, and that was cured by yourself, albeit in the face of both a Superior Court injunction hearing and an appeal to the ABCC. That you, on your own, reconsidered, reversed, and allowed the renewal for the same, after denying that renewal on these for the exact same reasons in December of 2024. That is not permitted. That is unlawful action. You are bound by your decision in January of 2025 and cannot go back and revisit and get a second bite at the apple, as the adage goes. I have, in the motion to dismiss for res judicata purposes, I have a more fully developed statement of the facts devised from the public records of the commission and the video of the December 2024 meeting and the January 2025 meeting, as well as a discussion of the principles of why you cannot now go back and revisit on the same grounds that you just allowed renewal of the license in January 2025. I'm happy to answer. I would submit on that motion without waiver of the statement of facts or the legal principles and arguments advanced, and I'm happy to answer any questions that the chair or any member of the commission might have.
I don't have any. Do you, David?
Thinking. Okay.
No questions?
No.
Good afternoon again, Commissioners. With respect to this motion to dismiss on the grounds of res judicata, this is a very easy one for you, I would suggest. That is because the renewal process and the proceedings that you had was about just the issue of renewal. And it is completely different than the hearings that you've noticed today, which the hearings, and I'll just read briefly from the notices, concern the conduct of whether or not there's been an illegality committed on the licensed premises in violation of the state law and the local rules within Woburn. So in other words, when you made the decision with respect to the renewal, that was about whether or not the license should be renewed. And obviously, it's been documented that you reversed yourselves on that. And that is a completely separate issue than what we're here today about. So there's no, the decision that you made previously in January when you said, okay, we will reinstate the licenses and renew them for 2025, that is a completely different set. It's not binding. What you did then is not binding on today, and it does not certainly foreclose this hearing. And so it's very simple. There was no final unappealable determination on the same issues and the same facts. So I would commend that you deny this motion to dismiss, and let's move on to the next motion.
Motion to deny, each motion to dismiss.
Second.
Motion made and second. All those in favor?
Aye.
Aye.
All those opposed? Ayes have it, 3-0. So now the, go into the hearing aspect of it, or?
Respectfully,
oh, the
Mr.
final
Crowley has
motion, sorry.
one more motion to dismiss.
One more motion,
This
I
is
got
the
you.
Second motion to dismiss. This is on the statute of limitations. I'll let him speak to it.
Yes.
Thank you, Mr. Chair, through you to the members of the commission. What you have before you now is the second motion to dismiss filed by the Doghouse and Taste of Brazil. Once again, when I refer to the Doghouse, I mean the Doghouse Bar and Grill, LLC. When I refer to Taste of Brazil, I'm referring to Taste of Brazil-Tudo na Brasa, LLC. This is a motion to dismiss based upon the unprecedented accusation made for the very first time in February of 2025 that in fact various actions occurred as far back as July 2016. It is clear that there is a statute of limitations. That is a time frame within which the government must initiate properly actions to hold licensees accountable for perceived or imagined wrongdoings. That time limit is generally 3 years, maybe 4 at the most. Applying that principle of law to the notice that was the first proper notice that was issued by email on Friday, February the 27th of 2025, it is clear that 2016 is well beyond the limit. It is more than 8 years and 7 months prior to the date, the amended notice, which is the controlling notice for this hearing, and I suggest the first legally valid notice. Accordingly, you can only consider today allegations that fall within the statute of limitations. July of 2016 does not. The result of that is the amended notice of hearing is defective. There has been no motion to amend it to fall within the authorized and permitted period of time. This hearing must be dismissed for that substantial and uncured legal defect. You have in front of you a motion that more fully develops the facts and the legal arguments and the bases on which we base this motion, and I do not waive that by my highlighted points brought up here during my oral presentation. With that, again, there is one motion from the doghouse. There is a second motion by the Taste of Brazil, and I'm prepared to answer any questions the chair or any member of the commission may have about this second motion to dismiss.
So, Attorney, just to be clear, are you suggesting that you wanted us to take action during an active investigation?
Well, there's nothing in the record that suggests an active investigation. However, to answer your question, given my experience as an alcohol regulator at the state level, yes, a choice has to be made. You either defer and let the criminal process run its course, or you act timely as an administrative body, like the ABCC did from time to time, and you basically give the licensee a full shot at free discovery, because they're entitled to that under a fair hearing and the well-recognized, well-established principles of due process. You cannot just sit idly by and do nothing for 8.5 years. You have a burden to act timely. This allegation that goes back to July 2016 is defective. It cannot stand. It cannot move forward. The only choice you have is to dismiss the amended hearing notice regarding Doghouse and the amended hearing notice regarding Taste of Brazil. Subject to my fact that I did not waive any arguments or position, I'd be happy to answer any other question the chair or any other member of the commission might have about this.
Just want to talk to the two of you.
I'll take a minute.
Yeah.
We just have a minute?
Well, I would suggest you consult your counsel as to parameters of your obligations to have deliberations in an open public meeting like this one.
Okay.
But I have no objection to you consulting him in a confidential basis, so long as it doesn't violate the open meeting law.
Attorney?
I would suggest you make a motion to go to executive session for 5 minutes.
Please. I can't hear you.
Make a motion to
Oh,
go
I'm
into
sorry.
executive session
Wants us to
for
go into
5
exec-
minutes. Hello?
Make a motion to go into executive session for 5 minutes.
Make a motion to go into executive session for 5 minutes.
Second.
Roll call?
Roll call.
Motion made and seconded. Roll call, please.
Commissioner Gilgun,
Yes.
Commissioner McGrath,
Yes.
Commissioner Skeffington,
Yes.
Chairman Skeffington.
Yes.
Motion is approved 3-0.
3-0. Take a motion to come out of executive session.
So moved.
Make a motion to come out of session.
Motion's made and seconded to come out of executive session. Roll call?
Commissioner Gilgun,
Yes.
Commissioner McGrath,
Yes.
Chairman Skeffington.
Yes. And for the record, there was no votes taken in executive session.
Motion to return to the regular order of business of this hearing.
Second.
Motion's made to return to regular order of business. All those in favor?
Aye.
Aye.
All those opposed? Ayes have it, 3-0. Attorney Dickinson.
Thank you, Chair Skeffington. So it's my opposition to the second motion to dismiss of both the Doghouse Bar and Grill and the Taste of Brazil. Again, we respectfully suggest that this motion should be denied. There's several reasons why. First of all, a statute of limitations has no application to this licensing commission. You have a broad range of discretion to determine the timeline of violations or alleged illegality that's occurred on licensed premises. But more importantly, the allegations in this case really only came to light in 2022 with the federal indictment of the owners of the licensees, as we'll get into shortly if we get to the main proceedings. And the fact is that the alleged illegal activities, and frankly, they're not alleged anymore because these folks pled guilty to them, occurred, according to the federal papers that will be submitted to you, as far back as 2016, but they were done clandestinely, and of course, this commission, nor any of the public, had any idea what was going on until the federal indictment started in 2022, and more recently, in fall of 2024, the two individuals that constitute the ownership of both the Taste of Brazil and the Doghouse pled guilty. So it was only until that time, I would respectfully suggest, that these, once these guilty pleas were entered, that the case really became ripe for this commission to consider and take action. And therefore, I respectfully suggest that this motion should be denied in the fact that these violations are able to be considered by this commission, should be considered by this commission, and there's no merit to their motion. Thank you.
Motion to deny the motion based on the statute of limitation issue.
Second.
A motion's made and second. All those in favor? Aye. All those opposed? Ayes have it, 3-0. All right. Now we're hearing, now we're going to get into the hearing aspect of it. Is that better? You guys hear better out there, or was it just me?
We can hear better.
All right. I guess no one wants to talk. So as far as the hearing goes, before we get into the hearing, I'd like to set forth a little structure here. All right? I'd like to limit to 1 hour. The city will have up to 30 minutes to present their case, and the Doghouse and Tutor Brazil will have 30 minutes to present their case. Then we'll go 15 minutes each side for questions to the opposite side. So that's how we're gonna hold the meeting. Yes, sir. And I don't have a stopwatch, just so you know.
No, that wasn't my question. As you know, we have two licensees here that we have agreed to consolidate. So my request would be, in regards to presentations by each licensee, they each get a block of the time set out by the chair, so that they don't get halved on their presentation time.
Attorney Dickinson?
I think the chair suggestion is well taken, that there should be time limits. I'm fine if you want to, if the liaison gets 1/2 hour, and then each of the licensees gets a 1/2 hour each for a combined 1.5 hours total, that would be fine with me.
Okay. Attorney Kelly?
Just for purposes of clarity, I welcome Attorney Dickinson's acknowledgement that each licensee gets that time, block of time. That would also apply, my question is, that I assume that would also apply to the time for asking the other side questions. That is 15 minutes for each licensee.
I think we're going to go back and forth here for a while, but to clarify, I think if Attorney Kelly is saying he might need additional time for cross-examination, I would respectfully suggest that we just limit the time that each side gets, that the city gets 1/2 hour to present its case and do its cross-examination, and that each licensee, that be it the Doghouse and the Taste of Brazil, each get a 1/2 hour to present their case and include cross-examination, and that would be a reasonable time limit.
That sounds amicable. You agree with that? Yes?
If I may be heard on that,
Just pick the mic up a little bit.
sorry. I'll continue to steal your notes. Setting those time parameters would prejudice the two licensees who agreed to a consolidation because they're getting halved. My only question was to verify that, in fact, each licensee has the same time that the government will have, both in presenting their case and also in asking the other side questions.
Here we go.
I would suggest, we're going to be very brief and to the point, so I would suggest that, if you, I would request that you just keep each party to a half hour, being the city gets 1/2 hour, and if we don't use all our time, then that extra time could go to them. But I would keep it, otherwise we're going to be here all afternoon. I would keep it to an hour and a half of hearing time. I think that's
Yeah,
more than-
I would agree with you there.
Well, already we wasted 20 minutes going back and forth here. Let's make a decision.
So the decision's going to be as to each party, half hour. 1 hour. 1 hour per, then 15 and 15. All right?
I'm sorry, I'm not clear on that. What's the ruling of the chair?
As a structure of the hearing, limited to 1 hour, the city has an hour. City will have up to 30 minutes to present. The doghouse will have up to 30 minutes to present, and then 15 minutes and 15 minutes. So each doghouse and to the Brazil, you can have, what do we say, 30 and 30? Within that half hour, is that what we want to do?
We had said 30 and 30.
I would say just keep it 30 minutes for each party, and then that, they're on the clock, and so that would mean we essentially get a
what I
half
just said.
hour, and you guys get 1 hour.
Okay. I'm agreeable with that. You, David?
But just as long as Attorney Kelly is satisfied that we're not making an end run here.
Yeah.
Because that's what I'm feeling, that all throughout this process, we've been wrong. So let's let Attorney Kelly make the decision, so we'll be right for once.
Okay.
So what would you like,
So
Attorney Kelly?
I thought I understood, but then there was a last statement that made me unclear.
Well, let's make it clear right now.
So as I understand the ruling of the chair, each party has 30 minutes to present their case in chief. In each party, so that means the government, doghouse, and Taste of the Brazil, each gets 15 minutes for cross-examination and asking the other side questions. I thought that's what
Does
the ruling was.
that make you happy?
No. No time limits make me happy, quite frankly, because you are, particularly on the date of the hearing, substantially impairing the preparation that was necessary to prepare for this hearing, particularly given the fact that you're going back to July of 2016 for allegations with a binder that's 3 inches thick.
So, what will we do? Bring a lunch? And have this thing go on all night? Let's.
There's no
let's come
time
to a
limit for justice,
conclusion here.
Commissioner.
Let's come to a civil conclusion. What do you want?
I want no limit on the time for presentation of the case in chief. You've heard Attorney Dickinson represent to you that they're going to be quick. They're going to be brief. That may very well be the case for the case in chief presented by both Doghouse and Taste of Brazil. However, on cross-examination, I don't know how long that's going to take because I'm not familiar with Captain Murphy. I understand he's the only witness that's intended to be called to prove the case, and so I just don't know how long my cross-examination would be.
Well, you've heard Chairman Skeffington say he doesn't have a time watch. So let's get on with it and let's play it by ear.
Okay. So there's no time
And,
limits. then?
and if you go on and on and on, guess what? We're going to get the hook.
Oh, yes, absolutely. The repetitive questioning, et cetera, irrelevant questioning, that's fair game for a ruling from the chair to rein it in. And I try not to do that. I try to stay focused.
Again, parameters are such as that, okay? And like I said to you, I don't have a stopwatch, all right? Am I going to say at 15 minutes, that's it, sit down? No. But we need to have some guidelines, and we'll be flexible on them, all right? Fully understand that,
What,
but we're not,
Stopwatch if you need one.
what's that?
Have a stopwatch if you need one.
No. And so that's where we're at as far as the hearing goes. All right, so we're all in agreement there?
Again, I'm not clear. Is the ruling of the chair no time limits, but we have to stay relevant and not repetitive? Or are there time limits back again? I thought we were clear with no time limits, as long as it's not repetitive or irrelevant questions.
30, 30, 30, and 20 each for cross.
Per
Right.
per party?
Yes.
So that,
Okay.
so doghouse, and so we're clear. With all due respect, doghouse and Taste of Brazil each get their allocated time.
That's fine.
Correct.
Absolutely.
That was my only clarification. Just,
I can afford to skip a meal.
All right. Good afternoon again, Commissioners. Mark Dickinson for the liaison, Captain John K. Murphy. I just want to make a brief statement to orient you folks. So Captain Murphy has authored a report of several pages that was dated February 27, 2025. He is going to summarize and present that report. With that report, I understand he submitted to this commission already, but I will resubmit today. He referenced the federal docket, and at least 10 exhibits were appended to his report. That report that he submitted was submitted on February 27, 2025, and subsequent to the submission of Captain Murphy's report, there were certain additional events that occurred with respect to these licenses, and particularly the two individuals that own the liquor licenses that are involved today. And those events were that there was a filing of sentencing memos by each of the individuals or by their attorneys, and also they were actually sentenced. So that means we submitted a total of 5 additional exhibits to the commission subsequent to the report, and I have so together there's 15 exhibits that we're going to present to the commission today. So I am going to walk to my box here and give each of you a binder full of 15 exhibits that Captain Murphy, in addition to Captain Murphy's report. I've given a copy to Mr. Kelly. Mr. Kelly, in fact, has prior to today had full copies so he could prepare adequately for this hearing. So I am going to suggest that I will submit Captain Murphy's report and the 15 exhibits, and I will hand them up to you if you'll so allow me to do that.
Thank you.
Make a motion that we accept the,
Make a motion to accept the report. Make a motion to accept the, yes.
if I may, Mr. Chair, I have a number of issues and objections to many of the exhibits that are attached to that report. Also, if I heard correctly, and I'm looking for clarification and confirmation, that in fact the commission already since February 27th has been in possession of this report and the attached exhibits with no prior notice to the Doghouse, Taste of Brazil, or Council. And in fact, that is an egregious violation of the clearly established due process rights of both the Doghouse and the Taste of Brazil. That is ex parte communication, secret communication that is illegal. And the commission must not accept that and sanction, I suggest, those who engaged in that unlawful conduct by rejecting the report and all the evidence that was previously submitted in an unlawful ex parte communication. Separate from that, again, I'm happy to go exhibit by exhibit to express the issues and objections I have for certain exhibits.
Responding to what Attorney Kelly just said, all I know is that Captain Murphy said he submitted his report to the clerk. I have no idea whether this commission has even acknowledges that or knows about that, but confirming that in any event, we are submitting this report of Captain Murphy with 15 exhibits for your consideration, and I would request that you so move and allow us to present that so you can consider a full record today.
I make a motion to accept the report as authored by our attorney.
second.
Motion made in second. All those in favor?
Aye.
All opposed? Ayes have it, 3-0.
Attorney Kelly, do you have any exhibits that you'd like to present?
Yes, I do. First, I would, as a point of clarity, I would respectfully request a ruling from the chair and the members of the commission that, in fact, you have not, prior to today, reviewed, seen, or otherwise examined Captain Murphy's report of February 27th or any of the exhibits attached thereto that would constitute unlawful ex parte communication.
I would, Attorney Kelly has requested that you acknowledge whether or not you've received the report or reviewed it before today. That's up to your discretion as to whether you want to address that. I see no reason why you would not put on the record whether you've considered this or not before
We
today.
have seen Captain Murphy's report, and it was an excellent report.
Yes, we accepted them into our minutes. That's public record.
If I may be heard, Mr. Chair?
Can you speak into the microphone?
So, if I may be heard, am I recognized?
Yes.
Okay. The fact that the commission has now acknowledged, prior to the commencement of this hearing, you received ex parte communication, reviewed it, and just now commented favorably on the information that came through you by a totally unlawful process that is a clear violation of the constitutional rights of the Doghouse and the Taste of Brazil, I renew my motion to dismiss for prosecutorial misconduct through the unlawful submission of the report without prior notice or an opportunity to be heard by Taste of Brazil or Doghouse.
So help me out here, Attorney Kelly. I'm not an attorney, and I've never been accused of being brilliant. But what are you saying? We had no right to read Captain Murphy's report that he gave us?
Yes, that's what I'm saying. All information must be held unless and until there is a proper notice of hearing issued, the hearing is commenced, and the report is lawfully submitted for your consideration during the course of a lawfully noticed and convened hearing. If you don't meet those standards, you violate the law, again, and violate the constitutional rights of the Doghouse and the Taste of Brazil, both to due process that includes the right to a fair and impartial decision maker who only makes the decision based upon the facts and information that come to you during the course of the hearing in a method that is clearly reliable.
Well, how would you rate that with the Boston Globe? I read the Globe.
You
And
must
it was the
defer.
same thing as, it was the same thing as Captain Murphy was saying.
It is the same thing if you are reading unsworn published statements about the Doghouse of the Taste of Brazil that directly affect or indirectly impact any proceedings that are going forward here today about the Doghouse or the Taste of Brazil. It's same church, different pew. It's an unlawful ex parte communication that you, as a commissioner, must assiduously avoid.
Unbelievable.
Comment from
Mark?
I would suggest that we proceed with the hearing and that all of the issues that Mr. Kelly just raised, which is he's objecting to this report, can be cured and addressed on his cross-examination or his defense, whatever it may be, and we proceed with the hearing. We just presented the report and the exhibits to you, and now Captain Murphy is going to summarize it, and you can ask him questions, and then Mr. Kelly can cross-examine him. I think that's what gives the licensees their full, fair opportunity to address what's in the report, and we move forward from there.
If I may, I think it's neither accurate nor fair to characterize that, in fact, the report was just submitted when the commission members have acknowledged that you got that report and reviewed it back in February of 2025. While the hearing notice for today might have issued, it's still an unlawful and uncurable ex parte communication that undercuts your actions here today. Thus, I object, and I've renewed my motion to dismiss these charges for prosecutorial conduct by the unlawful ex parte communication from representatives of the government.
Motion to deny.
Second.
Motion made and second to deny the motion to dismiss. All those in favor? Aye. All opposed? Ayes have it, 3-0.
Is it my turn for exhibits?
Attorney Kelly,
Yes.
you.
I don't have a 3-ring binder. I have a little manila folder, but I do have documents that I would like to submit into evidence on behalf of both Doghouse and Taste of Brazil, if I may.
All right,
Make a
Attorney
motion.
Kelly, why don't you submit those when it's your time,
Oh, sure.
okay? Right now, it's their time, and we were talking about time, and now I think we owe them another 10 minutes, if we're gonna keep time, all right? Thank you. Captain Murphy.
Good evening. Well, not evening yet.
Yes.
Captain Murphy, Woburn Police Department, liaison to the License Commission. As council is notified that I submitted that report on February 27th to inform the commission of a violation of our rules and regulations according to the liquor laws. I submitted it to the clerk of the committee, Gordon Vincent.
Pull the mic in, Cap.
I submitted to the clerk, Gordon Vincent, through email, and and I assume he gave it to you people as well.
Yes.
Any questions on my report? Would you like me to read it? Whatever the commission, the summation is that we've had individuals that pled guilty in federal court to offenses, and those offenses were directly related to the operation of the Taste of Brazil.
Objection. That is a mischaracterization of, in fact, the federal proceedings. Nothing of the sort is of a plea like that was made, and I have a witness here who's going to explain that all to you and show you how wrong and how inaccurate that characterization is. I move to strike that response and characterization.
Denied.
Note my objection for the record.
What's he saying?
If you go through my report, the various federal documents are quoted and attached to that report to characterize how the operation of the system was going on. There is also a search warrant in there. The judge decided there was a nexus to both locations, so a search warrant was issued for both locations. There are forfeitures applying to both locations. Then there are plea agreements for both individuals on what their role was when they pleaded guilty to involving the Taste of Brazil and the Doghouse. Okay, if you go to in the second page of my report, copy of docket number, plea agreement, as the Hugo Giovanni Moraes pled guilty to conspiring to encourage and induce an alien to come, enter, and reside in the United States knowing or in reckless disregard of the fact that such coming to, entry, or his residence will be in violation of the law for commercial advantage or private financial gain. And we also have plea agreement as Jesse Morales pleaded guilty to conspiring to encourage and induce an alien to come, enter, and reside in the United States knowingly or reckless disregard for the facts that such coming to, entry, or residence is or will be a violation of law for commercial advantage or private financial gain. Jesse Morris also pleaded guilty to conspiring to launder the proceeds of the migrant smuggling conspiracy. Okay? And then if you go to page 3, okay, those are relevant to the indictments that were placed, and that's from the federal record. And if those all are the indictments. And then on page 4, on November 14th, 2024, at a hearing pursuant to the Federal Rules of Criminal Procedure, defendant Jesse James Maurice pled guilty to counts 1 and 8 of the second superseding indictment, the ones I just read. The hearing was Federal Rules of Criminal Presence. The defendant Hugo Maurice pled guilty to count 1 of the second superseding indictment pursuant to the written plea agreement that he signed on or about September 2nd, 2004. Also, if you, then halfway down that, 3/4 way down that page, $25,000 of the $60,000 in the United States currency seized on October 4th, 2022 at the Doghouse Bar and Grill, and B, $25,000 of the $211,912 in United States currency seized on October 4th at the Taste of Brazil restaurant. In his written plea agreement, the defendant Hugo Moraes admitted that the $50,000 in U.S. currency is subject to forfeiture on the grounds that it constituted and was derived from proceeds of the defendant's offenses, and/or was used to facilitate the defendant's offenses in violation of 8 U.S.C. I can read all those codes if you want me to. And the defendant consented to the entry of the order of forfeiture for $50,000 in U.S. currency. Then, in summary, Hugo Moraes and Jesse James Moraes are the owners and operators of both the Doghouse Bar and Grill and the Taste of Brazil. Each has pled guilty to engage in federal crimes involving the human trafficking that occurred between.
Objection, move to strike. There's nothing of the sort in the record. That's a gross mischaracterization and misrepresentation to this board.
Mike. Yeah. Chairman has a little trouble hearing, you know.
Oh, I'm sorry. He had the good microphone. I'm objecting to that gross mischaracterization that Captain Murphy just made as to the nature of the federal criminal offenses to which a plea of guilty was made. It had absolutely nothing to do with human trafficking. And the records of the federal court, which are attached to the report, speak for themselves without any need for Captain Murphy to read or mischaracterize to you what those documents say. I therefore move to strike and ask the chair to sanction Captain Murphy to stop with the mischaracterizations and tell the truth.
Go to the bottom of page 5.
Excuse me, Mr. Chair, there's a motion pending before that I request a ruling on, which is...
He's speaking on the motion right now.
Oh,
Attorney
okay.
Kelly.
Motion to deny such motion.
Second.
Motion made second. All those in favor? Aye. All those opposed? Ayes have it. 3-0. Motion made.
Kindly note my objection.
If you read through the federal paperwork, Hugo's primary role in the conspiracy involved hiring the migrants who worked at the Tutor de Braza Taste of Brazil and the Doghouse Bar and Grill, including setting their hours and work locations and paying their wages and helping migrants find housing, often owned in the apartments of his, and receiving or holding rent payments in cash at his restaurants. Then we go to page 7. Hugo appeared at the Woburn City Council meeting to represent the Doghouse to apply for a special permit for rooftop dining at 434 Main Street. The Doghouse liquor license, the new liquor license was approved on 2/18/2018 as Hugo Moraes as the manager. The ABC confirmed Jade Archdeacon as the manager on 3/29/23. The ABCC confirmed Hugo Moraes, brother of Hugo, as the manager on 5/3/24. Taste of Brazil. No liquor license was approved in 2007 with Hugo Moraes as the manager. There was a transfer of the liquor license in 2015 to another corporate entity, and Hugo Moraes is still listed as the manager. The ABCC confirmed Jade Archdeacon as the manager in 3/8/2023. The ABCC confirmed Hudson Moraes, brother of Hugo, as the manager of 5/20/24. On February 12th, 2024, Hugo Moraes, in an application filed with the Woburn License Commission.
If I may be heard, Mr. Chair? It was in regards to violations listed in the hearing notice, E, F, and G, having to do with license manager and false statements in an application. It was represented to me in writing that, in fact, there would be no prosecution moving forward, and those violations would be dismissed. I assumed that under the traditionally accepted notions of a fair hearing, the government would abide by the representation. Captain Murphy, in his zeal, seems to have crossed the line, and I would ask that you have a ruling now to strike all the testimony about license managers, strike all the exhibits about license managers, and dismiss formally, so we can move forward in an orderly manner, Violations alleged in the notice of hearing identified in paragraphs E, F, and G.
Commissioners, Mark Dickinson for the liaison. Just with respect to Mr. Kelly's request, we are not today going to ask you to make any determination as to the propriety of the manager part of it. So we'll withdraw. I know Captain Murphy just made some mention when he was reading from his report about the change of managers. So we'll just withdraw that statement and commend you to focus on the federal questions of whether there was an illegality on the premises. With that, go for it.
Okay. Sorry, Captain. Just 1 minute for clarity. So, for my clarity, allegations in the hearing notices E, F, and G are dismissed?
Well, we're not suggesting, we're saying for today, we're not proceeding on those, they were noticed for hearing. We are not dismissing them with prejudice, but we're saying that today, we're stipulating that they are not the subject of the violation hearing.
All right, but today's the hearing day. They go forward today or they don't go forward. They should be dismissed. Let's save the economy of time.
We're not agreeing that they be dismissed. We're withdrawing them from our presentation today. It's up to the commissioners as to whether you want to rule on that or not.
Motion? To accept? To move forward?
No. I'm not gonna rule on it.
Huh?
Move forward.
We're going to move forward. Make a motion to move forward.
Motion to continue the hearing. Move forward, please.
Second.
Motion made second. All in favor? Aye. Those opposed? Ayes have it, 3-0.
I'm not clear on that. Is the commission's ruling that you're taking evidence on violations identified in paragraphs E, F, and G?
We have a city solicitor here. Mark, help us out. We're, like I said, Attorney Kelly, we're not attorneys.
I would suggest that with respect to the issue of whether we're moving forward on E, F, and G, that you make no determination as to that. We're, as a representative of the liaison officer to this commission, I'm representing to you that we will not be presenting, we withdraw the statements that Captain Murphy made about the issues regarding whether their manager was approved or not properly, or whether there was any issues there.
Documents, too.
And any documents, too.
Motion to continue the hearing.
Second.
Motion made to continue the hearing. Seconded. All in favor? Aye. All opposed? Ayes have it, 3-0.
If I may be heard on the motion, what are...
Can I jump in?
Oh, go ahead. Sorry, didn't see you there.
I think it's correct if you would like to make a motion to, not to dismiss E, F, and G, but to disregard. And you can make that motion to disregard the evidence just presented on the manager issue.
I'd like to make a motion we disregard on the manager of issue.
Second, Bill?
Second.
Motion made and second. All in favor?
Aye.
Aye. All opposed? Ayes have it, 3-0.
I'm not clear what that motion just was. I'm sorry, Mr. Chair.
It was clear.
What word didn't you understand?
I heard Commissioner McGrath make a motion. I heard Commissioner Gogun second the motion, but there was no specification of what the...
second.
No, no, I made the motion,
Right.
not
Oh,
McGrath.
I'm sorry, I got that
He made
reversed.
the motion, he seconded it.
Sorry about that. But I didn't hear what that motion was. And that's where I lack
The
clarity.
city solicitor suggested we do. Would you like to tell him, Mark?
I believe the minutes will state that he made a motion to disregard the evidence presented regarding the manager.
That's
That was the motion.
E, F, and G.
Yes.
Thank you for the clarity.
Disregard.
Captain Murphy again. Okay, so, as a result of the above report, the Woburn Police Department issues a citation violation to Doghouse Bar and Grill for the illegality of, can't even say the word, on the license permits for violations of Woburn License Commission rules and regulations, Section H14, Section H26, and Section H27. As a result of the above, the Woburn Police Department issues a citation violation to the Taste of Brazil, Tudor, and Brazza for the illegality on the license premise for violations of Woburn License Commission rules and regulations, Section H14, Section H26, and Section H27. And the basis of that is that report, and that there was a search warrant conducted at the premise. There was a judicial finding that they were connected to the investigation, and the defendant pleading guilty, and the owner and co-owners, and the Taste of Brazil pleading guilty as well, to illegality on the premises, which involved using people, excuse me, I don't want to characterize it anything else. I don't have to read the charge again. So there was illegality going on the premise, and there was involved the operation of the restaurant, and the restaurant had a liquor license. So in doing that, the furtherance of the illegality was involving the liquor license of both places.
Any questions, David? Bill, any questions?
Thank you.
Thank you.
Just have one follow-up question for Captain Murphy, which is, can you tell the commission, since you submitted your report on February 27, 2025, has there, with respect to the federal cases, has there been any further action that might be relevant for the commission to know, if they don't already know?
The further action was that there was a sentencing hearing conducted to go for the actual sentencing for each individual for their role in the crime. And counsel has provided you with those sentencing memorandums from both sides.
Thank you.
I would suggest to the commissioners that now it's an opportunity for Mr. Kelly to cross-examine or question Captain Murphy or raise issues with his presentation.
Attorney Kelly?
Yes.
You can use the microphone to your right there. Actually, no, that one there's sound.
Is this the good one?
Yeah, that's the one.
Okay. I would note that we haven't discussed my objections to the exhibits that are attached to the Captain's Murphy report, so I don't know when the chair wants to take that time. You may recall that when the report was offered, I did have an objection and indicated I had issues and objections to many of the exhibits that were attached.
When we denied.
But there was no ruling in regards to that, and I did not have the opportunity to express what my issues and objections were.
Wouldn't? No?
I'd have to go back through my notes, Chairman.
I make a motion, we deny those points.
I don't know what he said.
Made a motion to deny the objection to the reports.
I could suggest, make a motion to overrule the objection. You could make a motion to overrule the objection.
Make a motion to overrule the objection.
Second.
If I may be heard before there's a second or a deliberation on that motion, you haven't heard what my objections are. How can you rule on something you haven't heard?
Attorney Kelly,
Yes, sir.
say that again, please.
I'm suggesting that I have not had the opportunity to be heard on the specifications of what the legal issues and my objections are as to the exhibits, many of the exhibits, not all, but many of the exhibits that are attached to Captain Murphy's report. In light of that, I respectfully suggest it's premature and indeed a denial of due process to have any motion to overrule an objection you haven't even heard yet.
Yeah, I agree with that. I agree with that.
I heard it.
Commissioners, Mark Dickinson again. I would suggest that we proceed as follows, that this essentially is Mr. Kelly's opportunity to cross-examine and object to the case that was presented. So he has issues with the documents that were presented. I see no harm in allowing him to list out his objections and educate you on what his position is. And if in the course of doing that, he has questions for Captain Murphy, he should be allowed to ask them. So I would suggest
I think that's
that-
fair, don't you, Attorney Kelly?
Well, that was the purpose of my original question, Commissioner, was to be clear that we haven't had that conversation yet about the
Right.
exhibits.
You're
And-
right.
And I'm prepared to ask Captain Murphy
Great.
questions, subject to the permission of the chair.
Make a motion.
Motion to continue the hearing with Mr. Kelly questioning Captain Murphy.
Second.
Motion made and second. All in favor?
Aye.
Opposed? Ayes have it, 3-0.
All right, we're official. So, good afternoon, Captain Murphy.
Good afternoon, Council.
If I ask you a question that you don't understand, please let me know.
I will.
And I'll try to rephrase it. If you don't hear my question, I'll try to speak louder. Same for if I lose you. So my first question is, Captain Murphy, you want to be fair during this hearing, don't you?
Absolutely.
And how long have you been a member of the Woburn Police Department?
It'll be 37 years,
Okay. And how long have you held the rank of captain?
since 2005.
Do you hold a civil service tenure in the rank of captain?
What do you mean by that?
Did you attain the rank of captain after taking an open and competitive examination for the promotion to captain?
I did.
Okay. So you have civil service protection in your current rank?
I do.
Okay. And would it be fair to say that that gives you a certain independence of your judgment making during the course of performing your duties?
I think that's the whole purpose of the civil service system and law.
Okay. So do you have a superior officer that you report to?
I report to the deputy chief and the chief of police.
Okay. So you have two direct reports?
Attorney Kelly, can I slow you down a bit? I'm not supposed to.
Oh, I'm sorry. I thought this was being video or audio
It is,
recorded.
but it's coming fast and furious.
Oh, okay. Yes.
Fast and furious.
My
Thank
apologies.
you very much.
My zeal
I
overwhelms me.
understand.
So all set now?
Go ahead, thank you.
So you have two persons that you directly report to in the chain of command?
Chain of command, yes.
Did you receive any orders from the chief regarding any activity with the doghouse?
I don't understand that. What do you mean by orders at any activity?
So you indicated that you commenced an investigation into the doghouse?
The allegations, commence an investigation for the purpose of a liquor law violation, yes.
And who gave you that order?
No one gave me an order to commence an investigation. Part of my job is allowed to initiate investigations.
Okay. Did anyone give you an order to initiate an investigation into the Taste of Brazil?
Not that I can recall.
And are you a designated or appointed agent of the Woburn License Commission for purposes of enforcing Chapter 138?
Not an agent, no.
Okay. Do you know if any member of the Woburn Police Department is designated as an agent of the Woburn License Commission for the purposes of enforcing Chapter 138?
There was some discussion about that a while ago, well, many years ago, and there was talk that it was going to be done. I don't know whether the city actually officially did it.
But you're clear that you are not, you don't have the designation of agent of the Woburn License Commission for...
No, I work as the liaison to the...
Okay.
That's been clear.
And the liaison is between the police department and your traditional police duties and the Woburn License Commission. Is that fair to say?
Correct. That would be it'll be a good characterization of it.
Okay. So are you familiar with a member of the Woburn Police Department by the last name of Shaughnessy?
Yes, I am.
Okay. How are you familiar with that individual?
Inspector Shaughnessy is a retired Woburn police officer.
When did he retire?
Are we getting into this?
I'm gonna... 3 months ago, is it now, or a month ago?
Okay.
Recently, really recently.
To your knowledge, did you say Inspector Shaughnessy
Yes.
write any reports regarding the doghouse?
Not submitted to the Woburn Police Department.
But did he write reports to anyone?
I do not know that for a fact, yea or nay.
Okay. Do you know whether Inspector Shaughnessy wrote any reports regarding Taste of Brazil?
Not to me,
Okay. Do you know if any reports were submitted to anyone?
not to my knowledge.
Okay. Now, isn't it true that you made no personal observation inside the doghouse regarding your investigation?
And I've been inside the doghouse, yes.
And did you go inside the doghouse during the course of your investigation into license violations?
No,
Did you go into doghouse as a patron?
I don't think I've ever been there.
Did you go into the Taste of Brazil in the course of your investigation as to whether the Taste of Brazil was complying with the law?
I did not. I went into Taste Brazil and Doghouse in my performance as signing off in their liquor license applications.
As a administrative inspection?
Correct.
That's fair to say?
Correct.
Okay.
I don't want to mischaracterize, I've never been in there.
Okay, I understand. Thank you for that candor. Do you know how many hotels there are in the city of Woburn?
I think we're up around 13 now,
Okay.
give or take a few.
And would it be fair to say that all 13, you believe, hotels in Woburn hold licenses that are issued by this Woburn License Commission?
All their other licenses, not to mine, I don't know about the other licenses, I know about the liquor licenses.
Okay. But, so you don't know that to operate a hotel, they would need an in-holders license?
Yes, I do know that.
Okay.
But I don't have intimate knowledge of each person's license, each hotel, and all that.
I see. And is there any entity in the city of Woburn that issues in-holders licenses other than the Woburn License Commission?
Not to my knowledge. I wouldn't have that knowledge anyways, because it's not part of my job function to do in-holder licenses.
Are you aware that at least 5 hotels in the city of Woburn have been housing undocumented migrants or illegal aliens, or I'll use a third phrase if someone wants to suggest it?
Yes, on a program, not that to my knowledge, but I've heard about that through the state, yes.
And in fact, are you aware that Mayor Galvin has issued at least 2 public statements in regards to that activity?
I have not read them.
And would it be...
Clarification on the mayor. Current mayor or the former?
Is it Galvin? I'll be over there, Council.
I'm sorry?
I hope you're out there, Councilor.
Thank you. Well, I have documents, so...
Right, I get it.
Okay. We'll get to that, I guess, eventually. And would it be fair to say that the undocumented migrants or the illegal aliens, or a third term you may choose to use, that are being housed by those 5 hotels in Woburn are being supported by taxpayer funds in the Commonwealth of Massachusetts?
Is there a question there, Councilor?
Yes, sir. Is it fair to say?
Yes, it is fair to say that. That they were under a government-sponsored program, yes.
Now, do you know the identity of the alleged undocumented migrants or illegal aliens that were involved with the federal case involving the doghouse?
I do not.
Do you know the identity of the alleged undocumented migrants or the illegal aliens that were involved in the federal case regarding the Taste of Brazil?
I do not.
So it's fair to say, if you don't know their identity, you have no basis on which to judge their basis of knowledge or their credibility.
I do not.
Okay.
Credibility on the agreement.
Okay. Do you know what promises, rewards, or inducements were offered by any government to those undocumented migrants or illegal aliens, or a third term, who were involved in the federal case?
I do not.
Do you know whether any promises, rewards, or inducements were actually delivered to any of those undocumented migrants, illegal aliens, or a third term by any government official?
I do not.
Have you had any communications between July of 2016 and January of 2025 regarding the doghouse with Chairman Skeffington?
I have.
Have you had communications between those dates, and I'll repeat them if it won't be helpful, with Commissioner Gilgun?
Yes.
Have you had any communications with Commissioner McGrath regarding the doghouse during those dates?
I have.
And have you had communications between those dates with Chairman Skeffington regarding the Taste of Brazil?
Yes.
Did you have communications with Commissioner Gilgun between those dates regarding Taste of Brazil?
I may have, but the if I remember correctly, it was vast majority of it was Doghouse. I may have mentioned Taste of Brazil.
Okay. And did you have any communications regarding Taste of Brazil between those dates with Commissioner McGrath?
Pretty much the same statement. I wouldn't.
Now, were each and every one of your communications during an open public meeting that was duly noticed with an agenda?
No.
You had, would it be fair to say you had private conversations with Chairman Skeffington about Doghouse?
One-on-one conversation, yes.
You had private conversations with Chairman Skeffington about the Taste of Brazil?
I may have. I'm not going to say no in those, what?
Did you have private conversations with Commissioner Gilgun about the doghouse?
Yes.
Did you have private conversations with Commissioner McGrath about the doghouse?
I did.
Did you have, were the form of those communications in writing with Chairman Skeffington?
No.
Were they emails?
Somewhere. An email I sent to the commission would have gone through the clerk of the commission.
Were they texts from your cell phone to their cell phone?
I don't recall any text, but there may have been something in the 16 years I've been doing this with Commissioner Skeffington. I don't recall any specific text.
And my question is focusing on the doghouse between the dates of July 2016 and January of 2025.
If there was very few. I don't recall any specific text, no.
Were there telephone calls that you made to Chairman Skeffington regarding the doghouse in that time period?
I believe I've talked to him on the telephone about it.
Did you talk on the telephone with Commissioner Gilgun about the doghouse in that period of time?
Not that I can recall.
Did you have telephone conversations with Commissioner McGrath during that time frame about the doghouse?
I don't even know if I have Commissioner McGrath's phone number. I doubt it.
Would you like it?
Honestly, I don't recall any conversation with him. As a matter of fact, I don't even recall any conversation with him.
Okay. And you had telephone conversation, strike that. Did you have telephone conversations with Chairman Skeffington between July of 2016 and January 2025 regarding Taste of Brazil?
Involving the same situation, probably, yes. I would say yes.
And did you have telephone conversations about Taste of Brazil in that period with Commissioner Gilgun?
If I did, I don't recall any specific ones, but I had verbal conversation with them.
And did you have telephone conversations at all with Commissioner McGrath about Taste of Brazil during that time period?
Not that I can recall.
Do you know or recall the record retention policy for documents for the Woburn Police Department?
Relative towards,
Any reports between July of 2016 and January of 2025 regarding the doghouse?
we should have them, depending on, there are some, if the report is of a sexual nature or things like, there are certain exclusions that we have to keep them. I'm not talking about public record. We should keep them.
Okay. And is there a record retention policy for documents involving the Taste of Brazil for those time periods?
There's a general record retention policy.
Are you familiar with the term ex parte communication?
I am.
And is it fair to say you understand it to mean a secret communication that is unlawful with the person that's going to make an official decision in a hearing or adjudicatory proceeding?
I believe that's a legal definition, yes.
Okay. And would it be fair to say that you, in fact, did have ex parte communications with Chairman Skeffington about the doghouse?
I've had conversation with Commissioner Skeffington in relation to a lot of procedural items involving the doghouse.
And a lot of those procedural items are related to the issues that are being discussed here under the notice of, the amended notice of hearing that issued?
A lot of them were relative towards the process by which the doghouse, if the people involving the doghouse in the case of Brazil were being investigated, the search warrant, and complaints the commission was receiving about that.
Now, before you had that ex parte communication with Chairman Skeffington, there had been no notice of a hearing issued yet, had there?
Not to my knowledge.
Okay. And did you have any ex parte communications with Commissioner Gilgun about the doghouse during the time period of July 6, 2016 to January 2025?
I wouldn't characterize it as ex parte, no.
Did you have communications with?
I think I've answered the fact I've had private conversations with them. How it's viewed by the law, that's not up to me.
But they were, when you say private conversations, so I understand you clearly, they were outside of a duly noticed,
Outside of a
agended, open public meeting.
Correct.
And you had similar conversations with Commissioner Gilgun about the Taste of Brazil? Private conversations outside of an open public meeting?
Correct.
And are you aware that, in fact, Inspector Shaughnessy's wife owned a business, I believe it might be a beauty salon, in close proximity to the doghouse?
I do.
In fact, is it fair to say that business is adjacent to the doghouse?
I believe it is.
And are you aware whether Inspector Shaughnessy wrote any report regarding his wife's owning a business adjacent to the doghouse?
Not that I've seen.
And are you aware that Inspector Shaughnessy would...
Oh, let me rephrase that. Not that I recall seeing it all, no.
Okay. Are you aware whether Inspector Shaughnessy wrote any tickets for cars parked in the proximity of doghouse, but also in the proximity of his wife's business?
I have no idea who writes tickets.
Does the Woburn Police Department have a written code of conduct for all its members?
We have policy procedures, yes.
And are those public records?
Yes.
Is that code of conduct embodied into any type of organized labor agreement? Let me rephrase that question. Are there any unions that represent any members of the Woburn Police Department?
There are associations, not unions.
And is the written code of conduct incorporated into any labor agreement with those associations?
I think that would be a question for the chief to answer.
To your knowledge?
I'm not privy to any of that. There might be. I just don't. I think that the chief would be can answer that question.
To your knowledge, does the code of conduct for the Woburn Police Department prohibit an officer from using his official position to benefit family members?
That sounds right.
And would you agree that members of the Woburn Police Department are subject to the state ethics laws?
That is true.
And would you agree that the state ethics laws prohibit a member of the Woburn Police Department or any other municipal employee from using their official position to benefit a family member?
That's the, yeah, I believe that's in the law, yes.
Okay. To your knowledge, did Inspector Shaughnessy file any disclosure in writing to dispel any appearance of a conflict of interest by investigating Doghouse that was located next to his wife's business?
Not to me.
Do you know if he filed that with anyone?
I have no idea.
Okay. Do you know who Inspector Shaughnessy's appointing authority was before he retired?
Would be the mayor of the city.
May I have 1 minute to check my notes? Thank you. Oh, I just need to check. I don't know if I have further. May I have 1 minute to review my notes?
I'll stay right here, Council. How's that?
Thank you. Do you need water?
No, I'm good.
Nothing to do with this.
What?
Thank you, Captain Murphy. I have no further questions.
It's gonna,
Redirect?
it's gonna appeal us.
Big boy. Okay.
No, tell him, this guy's a loser getting up now.
Good afternoon again, Commissioners. Mark Dickinson. I just have a couple of follow-up questions with Captain Murphy. Captain Murphy, with respect to the questioning about the records of the Woburn Police Department and any reports that may have been done, Did the submissions that you've made to the commission this afternoon and the report, were they based on any reports or information generated by the city of Woburn or its police department?
Objection. Cause for speculation by Captain Murphy. There's no foundation. He knows the basis or the genesis of any of those documents that were. I have to yell. I am objecting to that question as it calls for Captain Murphy to speculate as to what went into the genesis of these reports with absolutely no foundation being laid as to his basis of knowledge on which he would answer. Therefore, I suggest it's an improper question that calls for speculation and ought not to be allowed by the chair.
Mr. Chair, I would like to make a motion to deny the objection. We have been very patient. We let Mr. Kelly go on and ask questions. I believe we should ask our attorney also, to give him that way to also to ask these questions. So I'd like to make a motion to deny Mr. Kelly's motion.
Motion's made and been seconded. All those in favor? Aye. All those opposed? Ayes have it, 3-0.
Kindly note my objection for the record, please.
Say that again?
Kindly know his objection for the record.
I'm objecting to the vote to overrule my objection, and I just needed to put that on the record. That's
Thank
all.
you.
So, Captain Murphy, you can answer the question that I posed to you about the source of the records presented to this commission today.
The reason why you have the documents attached to my report there is to reference they're from the federal government. They were obtained through the PACER, which is the electronic court documents from the federal government. I included them so you could reference them and go back and look at them to see exactly where I didn't alter those documents. I didn't change them. I just got them from I got some from PACER, and the attorney gave me some as well. So that's where I got those reports. That's why they're attached. And I didn't write those reports on the back. I didn't alter those reports in the back. I just attached them as a reference from my report.
Thank you.
Captain Murphy, just to clarify, were any of the reports that have been submitted to the licensing commission from the Woburn Police Department?
Well, my report that you see is from the Woburn Police Department, but they were based solely upon the record under PACER, which is the federal filing system for federal courts.
Thank you for that clarification.
All right. No further questions, and that concludes the presentation of the liaison for the city of Woburn.
Any questions, Bill? Nope. David? Attorney Kelly, anything?
This one's better? Mr. Chair, as I understand it, the prosecution has rested their case in chief. They have no further evidence to offer?
Correct.
I'd say yeah.
Yeah, he did.
Mark, did you hear that? Did you hear what? You hear what Mr. Kelly
You
said?
just rested, right?
Yeah. We rested, that's right.
Yeah, okay, want to make sure.
Right, I don't want to be premature. So, if I may, Mr. Chair, at this time, I would make a motion for a required finding of no violation because the allegations that went forward have failed to be proven by prima facie evidence through proper admissible evidence. You have absolutely no evidence submitted to you under oath. There was not an oath administered to Captain Murphy before he started his discussion. It must be presented under oath for you to make a valid, legally sustainable decision. It wasn't. Further, there is an allegation of violation of the ABCC regulations with absolutely no proof by the submission of certified copies of those regulations that is a requirement to establish their reliability. The prosecution has failed wholesale at offering any competent evidence on that point, and also they have had a similar failure by not producing certified copies of the regulations of the Woburn License Commission, which is a necessary component, a necessary element of proof to sustain the allegations that were formed in the amended notice, all of them. Accordingly, you have no choice but to make a finding of no violation due to the failure on the methods of proof, and I so move for that at this point. I'd be happy to answer any question the chair or any member of the commission have.
I respectfully suggest that Mr. Kelly's motion for required finding of no violation should be denied. The reasons are this. First of all, the chair and both commission members have a binder.
You speaking to the mic?
Sorry about that. The chair and both commission members have a binder. Inside that binder are 15 exhibits. Two of the most important exhibits are the plea agreements that were submitted by the licensees. That would be the plea agreement, which is exhibit number 4 in your packet. It's a letter dated July 25th, 2024. It was signed on the next to last page by Jesse James Moraes, who's a defendant in a federal criminal prosecution who pled guilty to a count that involved, if you look at the statement of facts in that guilty plea, by his own admission, he pled guilty to committing illegal acts with respect to both of the license entities that hold liquor license in the city of Woburn that are subject to the hearing today. And I commend you to look at the statement of facts attached to Mr. Jesse James Moraes' guilty plea, in which he admitted that not only did he commit illegal acts by paying people under the table, by employing people for the purpose of using their earnings to pay for smuggling fees, and by also essentially failing to follow federal law with respect to making sure they were appropriate to be working in the United States. That document is before you. You don't need anything under oath because we have an admission from one of the licensees who pled guilty to a federal indictment. Secondly, you also have the plea of the other 100% owner of the two licensees, and that is Hugo Moraes. That document is before you in Exhibit 3. That, again, is a guilty plea, and again, it admits under his own hand to a statement of facts that indicates he committed illegal activities on the premises of both licensees, the Doghouse and the Taste of Brazil. The other facts are that you have, and these are, Captain Murphy explained to you, these are federal documents that are reliable. He pulled them off of Pacer, which is the usual computer system, which is the database for all federal cases. These are standard, reliable documents. So there's two guilty pleas in which both gentlemen that constitute the 100% beneficial ownership of both the Taste of Brazil and the Doghouse have admitted to essentially using both of those licenses as a criminal enterprise, an instrumentality to essentially employ migrants and to not pay them proper wages and to use their funds as a means to repay smuggling. And in fact, some of the other documents that are before you are the orders from the federal court in which the federal judge in that case, upon a motion from the United States government, ordered the forfeiture of funds from each of the licensed premises. And as Captain Murphy summarized, each found on each of these licenses, which is licensed by this commission, each of these companies had, when there was a search done by the federal agents, significant amounts of cash that were part of this criminal enterprise. And they both agreed in writing. Mr. Hugo Marias and Jesse James Marias agreed in writing that the $50,000 of the funds that were found on the premises of the Taste of Brazil, it would be $25,000 of the funds on the doghouse would be forfeited, and $25,000 of the funds of the Taste of Brazil would be forfeited. In other words, both of these gentlemen admitted that significant cash amounts used at the business were part of criminal activity, and that was money that was seized on October 4th, 2022, which is well within the time period for you to consider as to whether there was illegal activities. So I would submit to you, in sum, that Captain Murphy has come before you and credibly presented that there's been federal guilty pleas by the two gentlemen that own together, they're the individuals behind the companies that own each of the two licenses, or the two businesses that have the liquor licenses. He's come before you with reliable information, a packet of 15 documents that in sum and substance demonstrate by their own admission, this isn't Captain Murphy's statement, he's just simply presenting you admissions from the two gentlemen that have the privilege of holding these liquor licenses. And so I suggest that this commission is within its rights. You're not bound by the rules of evidence. You're bound to accept reliable information. This is reliable, credible information, and you can take judicial notice of the fact that we don't need certified copies of the rules of this licensing commission to know that the license, and we all know because we're here, because the allegations are the fundamental question: did illegal activities occur on each of these under the liquor licenses during the operation of each of these licenses, the Taste of Brazil and the Doghouse? And the resounding, undisputed facts are yes, illegal activities occurred, funds were used, and these gentlemen who own this premises agreed that some money should be forfeited. And so there clearly is a reliable basis that an illegality happened on this premises, and that's a violation of your rules for the licensing commission. It's a violation of the Code of Mass Regulations that govern the ABCC. And so I would respectfully suggest that you deny the motion.
Motion to deny the motion by Mr. Kelly.
Secondly.
Motion's made and been seconded to deny. All in favor?
Aye.
Aye. All opposed? Ayes have it, 3-0. Is that all for the doghouse as we speak? Yeah? Move on.
It's not. I have a number of exhibits to offer, not nearly as voluminous as the police department, but documents nonetheless. Council has a copy of my folder.
Make a motion, we accept the,
Make a motion to accept. Second?
Make a motion to accept the exhibits from Mr. Kelly.
second.
Motion made to accept.
Just for the record, I have no
Favor?
objection.
Aye. All opposed? Ayes have it, 3-0.
Do you want to say something, Matt?
I just wanted to confirm I have no objection. I'm fine with
okay.
you accepting them.
For my clarity as far as procedure, when are we going to have the discussion about my issues and objections to the exhibits to Captain Murphy's report? Do you want me to proceed with my witness? as,
Please,
and then we'll have the discussion after that?
please.
Certainly. I would call Paul Kelly to the witness stand, please. Just need to get my notes. Good afternoon, Mr. Kelly. Would you state your name and spell your last name for the record?
Paul Kelly, K-E-L-O-Y, no relation to Mr. Kelly.
The commission would note I spell my last name E-Y. And we can have a conversation about that, I guess, at a more opportune moment. Would you introduce yourself to the License Commission members with describing your current position of employment?
Yes, I'm an attorney at the law firm of Jackson Lewis. I lead two practice groups, the White Collar and Government Enforcement Practice Group, as well as the Collegiate and Professional Sports Practice Group. And I've been with Jackson Lewis for about 12 years, and I've been practicing law for over 45 years.
And do you have any prior experience as an attorney with federal law?
I spent 10 years with the United States Attorney's Office with the Department of Justice here in Boston. Several of those years in a supervisory position. I was chief of the Organized Crime Drug Enforcement Task Force for about 2 years, and for about 3 years I was chief of the Public Corruption and Special Prosecutions Unit.
Do you have any knowledge about the federal case involving Hugo Moraes?
Since I was Mr. Moraes' lawyer, yes, I have extensive knowledge.
And do you have any knowledge about the federal case involving his father, Jesse Moraes?
I do.
And have you seen the amended hearing notice for the doghouse that brought us to the hearing here today?
I have.
And have you seen the amended hearing notice for the Taste of Brazil that brought us here today?
Yes.
Could you describe for the members of the commission what was adjudicated in the federal case regarding Hugo Moraes?
Yes. If you don't mind a narrative, I think it would be helpful. Because there's been a great deal of kind of misinformation which has occurred in this particular case.
Can you pull the microphone in a little closer?
Yeah, sorry.
Thank you.
This investigation by my former office was ongoing for about 3 years. The clear focus of the investigation was on a fellow by the name of Shelby Moraes, who is the brother of Jesse Moraes and the uncle of my client, Hugo Moraes. Shelby Moraes was being investigated for being involved in a fairly sizable smuggling operation where he was smuggling migrants from Brazil through Mexico and into the United States and charging them a large amount of funds, typically around $20,000, in order for that to occur. Unfortunately, what happened was there were certain developments. The government had hoped to lure Shelby Moraes into the United States. He was living in Brazil so that they could arrest him and prosecute him. But certain things took place in the investigation which required the government to kind of jump the gun and go forward. And so that the only, basically two people, there was one or two other miscellaneous players, but the only two people that they were able to charge at the outset was my client, Hugo Moraes, and his father, Jesse Moraes. In all the years that I have been prosecuting as well as defending cases, I've never seen a case quite like this one, which was based entirely on a cadre of unnamed, anonymous witnesses, each of whom entered the United States illegally, each of whom then received all kinds of extensive protection from the Department of Homeland Security to enable them to stay in the United States, not only during the course of the investigation, but going forward. These people otherwise would clearly have been deportable, and especially given the Trump administration, would likely already have been deported. The situation here is that initially Hugo Moraes was charged with 6 counts in a case where it was effectively overcharging by my former office. Most of the allegations against Hugo Moraes and his father are false, exaggerated, or simply made up by these migrants who basically told the government whatever they wanted to hear in order for them to get this permission to stay within the United States. My client, Hugo Moraes, was adamant about not pleading guilty and going to trial in this case. He proclaimed his innocence from the start. They had no hard evidence against him of any kind. They had no tape recordings, surveillance photographs, all they had was this collection of unnamed, undocumented, and anonymous witnesses. The problem was that at the plea stage, the government took the position that they would only take a plea from both Hugo Moraes and his father, Jesse Moraes. If one decided not to plead, then they wouldn't take a plea from the other. Jesse Moraes, the father, due to his age and other factors, was adamant about not wanting to go through a trial and wanting to plead. And my client, very reluctantly, to help his father, agreed to plead guilty. And he did so only when the government agreed to dismiss 5 of the 6 charges against him and to concede the fact that my client, Hugo Moraes, had nothing to do with this smuggling operation which had been perpetrated by his uncle Shelby for several years. In fact, my client had no contact with his uncle dating back to 2018, or roughly 7 years. They had had a falling out, and he hadn't spoken with him in many, many years. And so the plea agreement was the result of a negotiation, right? And what my client pled to was what we would call enabling. By hiring certain of these undocumented migrants to work in the restaurant, he enabled those people to stay in the United States where they otherwise would get deported or wouldn't be able to stay. And why did he do that? I suggest to you he did it for a couple reasons. One, out of compassion, out of caring, out of the fact that Hugo himself is an immigrant, came into the United States not illegally but lawfully, became a naturalized U.S. citizen, but understood that people coming into the United States from Brazil who don't speak the language, who don't have an income source, won't have any way to support themselves or their family. And so over the time that he ran these restaurants, he employed 10 to 12 of these people, a couple of whom only worked for a matter of days. And he did so basically out of as I suggest, caring and compassion. A couple of these people then turned and became these government anonymous informants that testified against them in a manner which was basically false and overblown. And when we talked about going to trial, the government decided that it didn't want to identify these people. It wanted to keep these witnesses secret. So we've never had a chance to question these witnesses, to examine their credibility or their bias or their interest. I can tell you that the evidence is very solid that Hugo Moraes had nothing to do with any smuggling operation, nothing to do with collecting smuggling debts, nothing to do with making threats against people, withholding money from employees, or any of the allegations that were initially made at the start of this case, most of which got dismissed. So the point is, and then there's been comment about the money. That was a product of a negotiation. What had happened is shortly before the search warrant, which took place in October of 2022, the 2 restaurants obtained 2 fairly significant SBA loans. And the money from those loans, which had just been received, was put in safes in each of the 2 restaurants. So they talk about there being a large sum of money that was connected to some illegality. Absolutely untrue. That money that was in those safes came from 2 sources. It was either the funds received from the SBA or rent payments. And just to make a comment about that, because I know it's been raised by the police department here, Hugo Moraes' in-laws own and rent out some apartments in the Woburn area. And for a couple of these people who became employees at the restaurant, Hugo would say, well, look, if you're looking for a place to live, you can contact my cousin and he might be able to help you out. That was the limit of Hugo's involvement with these apartments. He never received any kind of a fee, and the only reason that there was additional funds in the two safes at the restaurants was that the people who rented those apartments usually paid their rent in cash. They would put cash in an envelope. They would leave the envelope at the restaurant, and then the landlord would come by and pick it up. And those funds were also seized when the government came in and did this search warrant back in October of 2022. And so when we sat down with the government, the government has a lot of power. I had a lot of power when I was an assistant U.S. attorney. We negotiated the forfeiture of this case, right? There were several $100,000 in each of those two safes of legitimate money. We ultimately agreed to forfeit $25,000 from each of the two restaurants, just basically to kind of wrap this thing up and make it go away. One other comment I'd like to make, and it has to do with Inspector Shaughnessy. Early on in the investigation, we learned that Detective Shaughnessy from the Woburn Police Department was not only involved in the investigation with the federal officials, but was leading the charge. He was out there aggressively trying to convince people to give false testimony against Hugo and his father, Jesse. When we learned about this, we raised it with the federal court. It's a clear conflict of interest, a clear ethical violation for a law enforcement officer to be involved in an investigation which impacts your family directly. And what Mark Shaughnessy was doing was basically telling people not to be patrons at the Doghouse or the Taste of Brazil, not to attend those restaurants, telling people not to make rent payments to the Moraeses, ticketing cars that were parked in front of the restaurants.
Excuse me, attorney, can we keep to the specifics here?
I would object and say that at this point, we're running a little bit behind schedule, and respectfully, I think this is becoming narrative and closing argument rather than testimony about the facts in this case. So I'd respectfully suggest that the witness be directed to wrap things up.
Sustain.
I'd make a motion that we accept the objection of our attorney.
Second.
Motion made and second to sustain the objection. All those in favor?
Aye.
Those opposed, ayes have it 3-0. Can we just keep to what we're here for? It's, we're straying way off the course.
Well, just for the record, if you'd note my objection to restricting the witness's full explanation of his personal knowledge of the facts, particularly as it relates to the clearly improper motivations and questionable legality of the lead investigator from the Woburn Police Department. You have on the record Captain Murphy's candid admission to you that he really wasn't involved in that. His is basically an umbrella catch-up parroting of what others have done. Those others include Shaughnessy. So that's why, for the record, please note my objection to the commission restricting the full presentation of the facts and the improper motives of Inspector Shaughnessy, as testified to by Attorney Paul Kelly, the witness.
I would just make one last point on this, which is
1 minute, please.
the federal judges that we raised this issue with had great concerns about Detective Shaughnessy's involvement in this investigation for the reasons that have already been discussed.
Sounds like to me like an argument for a different venue, not a liquor license commission.
If I may,
You may, but I mean,
no, just for the record, to respond to the chair's statement, this is entirely an appropriate forum for this conversation because it cuts to the heart of the credibility of the prosecution's case. If it is motivated by improper, illegal conflict of interest, you ought not to give it further weight in determining whether the alleged violations have been proven with competent admissible evidence. Thank you for the time to
Yes, Bill?
make
In my humble opinion, I think that Mark Shaughnessy's name has been unfairly besmirched here. And I just, and I believe that we should go on and try to keep the focus as narrow as possible.
If I may, in regards to Commissioner McGrath's statement, we are working to be sure that we give you relevant admissible evidence. But this is not a narrow focus. Cross-examination in Massachusetts is not narrow. Our presentation of the case in chief to defend these overreaching allegations are exactly what Attorney Kelly is testifying to, so that you can have the full information and the full picture, not just the headline-grabbing, spin-doctor, fish-wrapping newspaper reports.
Are you referencing this, what you gave us, or no? The newspaper reports and all that, is that what you're referencing?
No, I'm referencing the documents that we're going to go through that are the attachments to Captain Murphy's report, about which I have legal issues and objections. Those documents that I admitted to you are official government statements from government representatives of the Commonwealth of Massachusetts that clearly establish the public policy in Massachusetts under the right to shelter law, specifically applied to undocumented migrants, illegal aliens, or a third term if you want to use, that are housed here in Woburn in 5 hotels that are licensed by you, and you haven't done a thing about it. You have allowed the singling out of the doghouse and the Taste of Brazil. That's unlawful, it's arbitrary and capricious, it's an abuse of your discretion, and you should not do that.
Attorney Kelly, L.Y., why don't you finish what you're doing there?
Thank you. Just one kind of closing comment. Basically, to summarize, the case against Hugo Moraes and his father is based on highly questionable testimony by people who have a strong motivation, to tell the government what it wanted to hear in order to get the benefit of staying in the country. There is no evidence that Mr. Moraes or his father were involved in active smuggling, making threats, collecting smuggling debts. A decision was made to plead guilty to end this. Trials are always a risk. But as I said earlier, my client was adamant about his innocence, wanted very much to go to trial, and ultimately decided to plead only to protect his father. Thank you.
Thank you.
If I may have one final question.
Attorney Kelly, L.Y.,
You.
you said twice that he had nothing to do with what was going on. Why would you give up your principle and plead guilty if that was the case?
Well, because he did acknowledge what we would call enabling someone to stay within the United States who's undocumented by having given them a job and paying them. And so that is a technical violation. Frankly, it's a violation which occurs in restaurants across Massachusetts all the time, but it's a technical violation. And so that was the way to resolve this, by acknowledging that enabling behavior and protecting his father.
Well, that's an expensive...
It is inexpensive, and he has misgivings about it to this day.
Thank you, Attorney Kelly.
Thank you, Attorney Kelly.
I have one last question for Attorney Kelly, if I may.
Yes.
Do you recall whether you got any information identifying whether any of the unidentified, undocumented migrants, or the illegal aliens, or third term you wish to use, received any promises, rewards, or inducement from any government official at any level in exchange for their statements on which the prosecution of Hugo and Jesse were based?
Shortly before the actual sentencing hearing, the government did disclose to us that they granted extensive promises, rewards, and inducements to the 6 or 7 witnesses that they had not disclosed the names of which 3 or 4 of those witnesses have criminal histories in Brazil, including a couple that had criminal histories for assault and other violent behavior. So the government basically went out of its way to make this case on the backs of people who came into the country illegally, some with criminal histories, and now they're enabling them to stay in the United States because they were able to make up these stories and exaggerations about Mr. Moraes and his father.
Is there anything else that you'd like to share? Any other information that you'd like to share with the Woburn License Commission today?
No, in the interest of your time, I'll respect your time and stop there.
Thank you, Attorney Kelly.
Attorney Dickinson, did you?
Thank you. I have one question, Mr. Kelly. You were the attorney who advised Mr. Moraes to plead guilty, is that right?
That's true.
Okay. No further questions.
Thank you.
Thank you.
Have 1 minute.
Where are we now?
That concludes our presentation in chief. We just have the dangling thread of my issues and objections to the attachments to Captain Murphy's report to get on the record and get a ruling on.
Did you make 3 copies of those?
I'm sorry?
Did you make 3 copies of those for us?
Oh, I did not. I just made one. Sorry.
So,
Gee.
Commissioners, I think what Mr. Kelly and I would stipulate, he takes issue with the 15 exhibits that I submitted to you. So he wants to give you his specific objections. And I think for the sake of completeness, I would agree that he should, if he can get them done within the next half hour, I would agree to allow him to do so.
I could get it done in 10 minutes if the commission sustains each one of my objections. I'm not objecting to every exhibit, but there's a few.
Well, you have the floor.
Working through the attached exhibit numbers, starting with number 1. Those are uncertified docket entries. I would object to those. There is then some unexplained criminal case cover sheet that is absolutely not relevant to any allegation pending before the License Commission. It should be stricken, as should be the docket that is identified as Magistrate Judge Bowles' docket regarding Jesse James Moraes. There is an affidavit in support of a criminal complaint that has no probative value and ought not to be admitted. It is here, multiple level hearsay that is manifestly not reliable and ought not to be admitted into the record of your hearing. That is identified as document 1 to 3, affidavit in support of criminal complaints. That is 50 pages long, signed by James Michael Staten, October the 3rd of 2022. Attachment number 2 is a criminal docket for a case with Judge Burroughs and Magistrate Bowles for Hugo Moraes. It has absolutely no probative value on any of the allegations of violation that have been made today. Number 3, I have no objection to. Number 4, I have no objection to. Number 5. It is a partial document with no reference to what case it's from. You're left to speculate where it's coming from. It is inadmissible, and I object to it and suggest that you do not include that in the record. Exhibit 6, similarly, it is a piece of a document, not a complete document, that has no probative value and is not relevant. The United States motion for forfeiture is irrelevant. It is simply a request. When you hear anyone say motion, you should hear, in common language, request. Requests mean nothing. And Exhibit 7 is nothing but a request. I object to it and suggest that it should not be included in the record. Exhibit 8 is a court order of forfeiture where a federal judge, Burroughs, has in fact back on January the 31st of 2025 issued a formal federal ruling in the federal enforcement of the federal immigration laws. I have no objection to that. Exhibit 9 is also a preliminary order of forfeiture from Judge Burroughs, dated January 31, 2025, regarding Hugo Moraes. Exhibit 9 was in the case of Jesse Moraes, I believe. I'm sorry, Exhibit 8, the preliminary order of forfeiture, was with Jesse James Moraes. Exhibit 10 is again a partial document, no explanation of where it's from. You're left to speculate and engage in conjecture. It has no probative value. The government's sentencing memorandum is essentially a motion, as I told you before. When you hear any lawyer tell you it's a motion, it's a request, period. It has no binding legal effect. It is nothing more and very analogous to someone bought a Powerball ticket. It doesn't say they won the jackpot. It doesn't say they won a prize at all. It ought not to be admitted. To the extent that it is admitted, you will want to look at page 3. Strike that, page 5, footnote 5, where the United States government admits paying off certain witnesses by giving them promises, rewards, and inducements that you heard Attorney Kelly testify were given to secure their cooperation and their testimony. That's called buying a witness, and that is substantially uncredible. You should reject that. You ought not to endorse it, and the City of Woburn License Commission should rise above that. The next one is...
What did you say? Paragraph 5?
I'm sorry?
Paragraph 5?
It's footnote 5. I'm sorry. Did I say paragraph 5? My apologies. It's page 5, footnote 5. Starting out with the words witness B.
Okay.
And it identifies how that witness was bought and paid for by the United States government, our government. Exhibit 12 is Hugo Moraes sentencing memorandum. I have no objection. Exhibit 13, Jesse Moraes sentencing memorandum. I have no objection. The criminal docket is Exhibit 14. I object to that. That has no probative value whatsoever as to any of the allegations here. And last but not least, Exhibit 15 is also copies of docket entries that have no probative value whatsoever. It is basically a recitation of a timeline and nothing more.
So 14 and 15.
Both dockets, and they have 14s for one federal case, 15s for the other federal case.
Thanks.
Good afternoon again. Mark Dickinson. I'm going to speak to the motion. Attorney Kelly has essentially moved to strike or object to all 15 exhibits. Essentially, he did agree to a couple of the key ones, which frankly are all you need to decide this case. He agreed that it is admissible and proper for you to consider the 2 guilty pleas of each of the individuals, Mr. Jesse James Moraes and Hugo Moraes, and he also agreed to the orders of forfeiture issued by a federal judge, which order the forfeiture of cash from each of the liquor licensees involved before you in this proceeding. In general, however, I would say, first of all of these documents that are before you, as Captain Murphy testified to, are reliable documents. They're literally, some of these documents, many of them are from the federal docket of the criminal actions that were held in federal court with respect to both Jesse James Moraes and Hugo Moraes. Those dockets reflect, first of all, that they were charged with criminal activities. Second of all, that they pled guilty to certain criminal charges. Third of all, that they were ordered to forfeit cash from each of the licensed premises. And fourth, each of them was then sentenced by a federal judge, respectively, to several months in prison with 3 years supervised release. And so in sum, all of these documents are reliable. Taken together, they give you a complete picture of the course of the federal investigation, along with the guilty pleas and the consequences that flow from those guilty pleas. And most importantly, the documents, especially the guilty pleas, Exhibits 3 and 4, describe exactly what activity each of these gentlemen who are combined, again, remember, these are the 100, together they own each of the businesses which hold the licenses. So the two folks that own the premises and were operating the premises specify in their guilty pleas exactly the conduct that they admitted, which was hiring migrants, allowing them to work there undocumented, and allowing them to work under the table for cash only. And it's not just one or two. They've admitted in their documents that it is at least 12. And so it's a course of conduct, and it's all in these documents. And I would suggest to you that all of these documents should be admitted, and you should move to deny the objection.
Attorney Dickinson, real quick. Help me out for a second here,
Sure.
all right? Because we're getting objections and, so I'm looking at this case 121 or 10175 A Bill B, document 268, file page.
Right.
Let's cut to the chase, all right? It's a simple question.
Sure.
It says here, defendant will plead guilty to counts 1 and 8. The defendant agrees that the attached statement of facts is accurate.
Right.
So if they have agreed, I'm trying to wrap my head around it, because you know what? Some of this stuff is it's way above my pay grade, all right? And I'll be 100% honest.
Yep.
But if you sign that, again, defendant agrees the attached statement of facts is accurate.
Right.
How can we object to that if the defendant, or in this case, the Moraes, both of them sign that?
Right. Well, I suggest,
That's
first of all,
what they did.
as a matter of procedure, Chairman, Mr. Kelly actually agrees that that document is admissible and is something that you can consider. And so I would commend that, right now the only issue before you is whether you're going to, he's objecting to certain of these exhibits. So that's the only issue before you for right this moment. I would suggest that you just move and allow them to overrule his objection. But then, with respect to your question, I'm with you, where I think this is a very simple matter. The two gentlemen that own...
Attorney Kelly can answer it. I don't know. I mean, I'm looking at it right in front of us from the United States Attorney's, U.S. Department of Justice, Joshua S. Levy, Acting United States Attorney, District of Massachusetts. And the defendant here, defendant's but he said that these statements are factual.
We agree. That's why we're here.
I don't know.
on behalf
I
of the
mean,
liaison.
Am I missing something here? Tell me if I'm missing something. I mean, they signed it. I didn't sign it. Bill didn't sign it. David didn't sign it. Captain Murphy didn't sign it. You didn't sign it. You didn't sign it. Attorney Kelly didn't sign it.
That's our case.
I don't know, that maybe it's just me. I mean, but, I'm, in layman's terms, I mean, I don't know. Why, if it's not factual and you're objecting to it, why did you sign it? You admitted guilt. You admitted guilt, 1 and 8. You admitted it. I don't care, I shouldn't say I don't care, because I do care. But, again, it's 3:45, and I'll stay here till midnight. I don't care, okay? I haven't heard once anybody say to me that the owner and manager of record did not conduct illegal or illicit activities at either location. That's what we're here for. I've heard a lot about this, a lot about that. I've heard, heard the government lies, and I'm getting stuff from, I'm heard about, migrant shelters, which, Attorney Kelly knows. Since the state put migrants in hotels, they stripped the local jurisdiction. We can't even go near the place. And they can't in Braintree, and they can't in Revere, they can't in any city or town. All right? The Board of Health and maybe the building inspector, and the police and fire. All right? Yeah, the local agencies, you brought it up, I'm answering your question. They've cut us off at the knees. We can't go in there, we can't enforce a thing. And one of the 4 you're referring to gave up their liquor license prior to taking illegal immigrants in. Wonder why that was. I don't know. I have an opinion on it. Thank you.
So, thank you.
I'll make a motion to deny Attorney Kelly's motion about eliminating certain aspects of this report.
Second.
Motion made to deny and second. All those in favor?
Aye.
Those opposed? Ayes have it, 3-0. So where are we at now? We're at the,
I think I will defer to Attorney Kelly as to whether he's finished the presentation of his defense and closed the evidence for himself and his clients.
Yes, I've finished the presentation of the defense in chief, so I rest.
that mic up a little. The guy before you was shorter than you. Pick your mic up a little bit.
Oh, I'm sorry.
Thank you.
Yes, I've finished my presentation in chief. We rest and are prepared to proceed to closing arguments.
Closing
What's that?
closing arguments, he wants.
Yeah, we'll proceed with the closing arguments.
So,
Uh,
You
wanna
have
go
the floor,
first?
Attorney.
I'm happy to go first.
Huh?
Thank you.
So
So-
is it closing arguments on both or just one?
We're a combined hearing, so I'm going to be doing closing arguments with respect to both licensees.
Okay.
So, thank you for your time and attention today. It's been a long afternoon. We're here about 3 hours in. Again, we're here because this is a violation hearing concerning both the Doghouse Bar and Grill, as well as the Taste of Brazil, Tudo na Brasa LLC. Both of those entities hold liquor licenses here in the city of Woburn. Both of them have been duly notified, at least as of March 5th, 2025, of the hearing that was to occur today. Both of the allegations against the licensees are similar. They're the alleged allegations are permitting an illegality on a licensed premises in violation of the Mass 204 CMR Code of Regulations 2052, and as well as the Woburn License Commission Rules and Regulations, Section H14. Both the state and local rules allow you or permit this license commission in its discretion to take an action of suspension or up to revocation of a license if you determine that an illegality has occurred on this premises. as we were just discussing and as we presented through Captain Murphy, it's undisputed that with respect to both licenses at issue, again, the Doghouse and the Taste of Brazil are both essentially owned, at the end of the day, they're on, if you looked at their license applications, the actual individuals that constitute the 100% ownership of each of those restaurants are Jesse Marias and Hugo Marias. As we submitted before you earlier today, and as has been agreed to, essentially, both of those gentlemen were subject to a federal prosecution, a criminal prosecution, in which each of them voluntarily, knowingly, and with counsel pled guilty to a criminal activity. And not only did they plead guilty to federal criminal activity, specifically in the statement of facts attached to each of the plea agreements, it itemized that with respect to each of these licenses, the licensed businesses that hold liquor licenses, that they did essentially agree that they were hiring migrant workers, undocumented, who were paid cash on the table, and that's what they admitted to. And they also admitted to this happening time and again over a time period from 2016 to 2022, when a search warrant was executed, and in addition to documenting the illegal activity, large sums of cash were found at each of these businesses, and as explained in the documents, the significant sums of cash, both Mr. Hugo Morales and Jesse James Morales agreed, and a court ordered that those proceeds from those businesses that were operating and generating money through a liquor license here in Woburn were to be confiscated, and they agreed because they were admitting to criminal activity. So in sum, this is an open and shut case. There has been a lot of smoke, there's been a lot of heat, there's been a lot of objections, but at the end of the day, we're not asking you to weigh on the credibility of Captain Murphy. We're not asking you to believe Inspector Shaughnessy. We're not asking you to do anything but look to the admissions of two gentlemen who operate a business here, and this is a sad day. A sad day for Woburn, a sad day for these gentlemen. But we're here because there's rules, and there's rules that 70 other licensees in the city of Woburn need to also understand and respect. And if we have two gentlemen that own and operate businesses here and are licensed, and they plead to a course of conduct of criminal use of those premises and agree to forfeit those premises, then there must be challenges. And one thing that I should note, I thought Mr. Kelly did a great job. I respect Mr. Kelly. He's a fierce advocate. But one thing that we did not hear today was any mitigation defense. We did not hear today that there's going to be a guarantee this will not happen again. We did not hear today that there's been steps taken to account for these actions so they won't happen in the past. We did not hear today what's going to happen when each of these men, who, as the documents show you, will be incarcerated for the next 5 months at least, and then on 3 years supervised probation. We did not hear how they're going to operate these businesses. So I respectfully suggest that you do what is common sense under this circumstance and find that there were proven illegalities on the premises, and use your discretion as to whether you want to suspend for a period of time, whether you want to suspend for their criminal sentences of several months, or whether you want to use the ultimate power that is available to you and revoke. Because these charges are extraordinarily serious. They represent a breach of trust of the community. And unfortunately, again, this is a sad day. We don't take this lightly to ask for a revocation of licenses. So I thank you for your time.
Thank you. Attorney Kelly.
Thank you, Mr. Chairman. So I would begin my closing argument by repeating and re-avering the points, the legal points that I made as the basis for a motion of a required finding of no violation earlier in today's proceedings. That is, that no evidence was submitted to you under oath. That in fact, there is no proof by competent evidence of what the ABCC regulations are, and there is no proof by competent evidence of what the Woburn License Commission regulations are. In addition, there are 5 points I would like to make in regards to why this commission ought not, and indeed, for certain reasons, cannot make any enforcement action grounded upon federal immigration law. So let's go through those. First, there is no evidence in the record whatsoever to support allegations as made in the amended notice of hearing that in fact money laundering was going on inside the premises of Doghouse at Taste of Brazil. It's just not so. That allegation must fail, and because it's not broken out into a separate count, all of paragraph A, I suggest to you, must fall. And you must find no violation on that reason alone for allegation A. Moving to allegation B, there is no evidence. First, it's duplicative. When you read it side by side with the allegations in paragraph A, it's duplicative of A. And there is no judgment, no evidence of any action of conspiracy for money laundering that occurred inside the premises of the Doghouse or inside the premises of Taste of Brazil. Therefore, you must find no violation as alleged in count B. Third, count C. Again, that's duplicative of the allegation in A and B above. Yet, there is a failure to produce any evidence whatsoever, no judgment, no evidence that any actions to advance a conspiracy for money laundering occurred in or on the licensed premises of the Doghouse or the Taste of Brazil. That is a gap you can drive a beer truck through. And because of that, you must find no violation. As to paragraph D, again, that is duplicative of the allegations in A, paragraph B, and paragraph C. And yet you have a failure of any proof, no judgment, no evidence of any actions of a conspiracy for money laundering occurring in or on the licensed premises of Doghouse or Taste of Brazil. I did not form the accusations. The government did. And when the government accuses, they are held to prove the accusations or risk an adverse finding. In this case, a finding of no violation. There's no other lawful conclusion. Second, the Doghouse and the Taste of Brazil did exactly what Mayor Galvin announced in 2 public statements that are in evidence before you did. That is, give homeless people shelter. That's all that was involved here. The difference is that those 5 hotels in Woburn that are housing these undocumented migrants or illegal aliens, or a third term you wish to use, are using taxpayer funds. All the hardworking residents of Woburn are paying to keep those federal felons, I suggest, housed. That's not what Hugo did. That's not what Jesse did. It's not what the Taste of Brazil did. And it's not what the Doghouse did. All they did was help certain persons, a finite, limited number, substantially less than what the United States government accused them of doing, to give them a hand up, to help them start the road towards the American dream that we have all participated in, we have all benefited from. You have in front of you additional exhibits that establish what the public policy of the Commonwealth of Massachusetts is in regards to the right to shelter law. You have a statement from the governor declaring a public emergency because of these undocumented migrants, illegal aliens, or a third term you want to use, flooding the territory of Massachusetts, and in particular, the city of Woburn. Mayor Galvin, in his 2 public statements, identified with particularity exactly the scope of the problem. That is not a problem created by the doghouse. It's not a problem created by the Taste of Brazil. I suggest to the contrary. Both the doghouse and Taste of Brazil cured that problem, avoided that problem, and kept people off the public dole, where they are a burden that is breaking the budget of the Commonwealth of Massachusetts, as even today, the Massachusetts legislature struggles with advancing the budget and passing the legislation to establish the budget for the Commonwealth as of July 1 of this year. All they did was comply with the right to shelter law that obligates housing be provided for the homeless. You have the August 18th, 2023 statement from Mayor Galvin saying more than 100 families, not 100 people, 100 families are being supported on the taxpayer's dime here in the city of Woburn. That's far in excess of the number of people you heard Attorney Paul Kelly tell you was involved with Hugo and Jesse at the Taste of Brazil and the doghouse. You have the September 19th, 2023 statement from Mayor Galvin, this before you in evidence, where over 1,000 migrant families per month are coming into Massachusetts. It's an unsustainable burden that we are now having to deal with. The Massachusetts Congressional Delegation sent a letter signed by Senator Warren and Senator Markey on September the 19th of 2022, again advancing the notion that there is a legal obligation to help undocumented migrants, illegal aliens, or a third term you wish to do. They are advocating for help through the expenditure of the tax dollars paid by the hard-working residents of the city of Woburn. That's not what Hugo did. He did the same conduct, but he did not use tax dollars. He used private funding. I suggest to you that actions of that nature are to be acknowledged and given the most beneficial treatment and not punishment. You have a similar letter on August the 1st of 2023 from the entire Massachusetts congressional delegation. You have before you the August 8th, 2023 statement of the Governor of the Commonwealth declaring an emergency, clearly establishing the public policy in Massachusetts is to do what was done at the doghouse and the Taste of Brazil, with private funding, no tax dollars. In short, doghouse and Taste of Brazil did nothing more than what Mayor Galvin did, Chief Rufo did, Governor Healy did, Senator Warren did, Senator Markey did, the entire House delegation for Massachusetts did, and that is simply this: keeping people out of the cold and the heat and giving them shelter so they would not be homeless. The difference, with a substantial legal difference, is taxpayer dollars were not involved with the actions and the civic mindedness of the doghouse and the Taste of Brazil. Point number 3. Municipal enforcement of federal immigration laws is preempted by federal law. The chair all but acknowledged this when, with frustration that I could hear to my ears anyway, you expressed that your legs have been cut, your regulatory legs have been cut off from under you by doing anything about the 5 hotels who hold licenses issued by you, whether they're common vittler licenses, in-holder license, or even a liquor license. And yet, Doghouse and Taste of Brazil have been singled out. That is not legal, that is not fair, and you ought not to permit that to happen. In addition to federal law preempting enforcement, the chairman has acknowledged that the state law enacted through the governor's emergency declaration and the state legislature's legislation with the power of appropriation have further preempted any municipal action in this field that is related to unlawful immigration coming into Massachusetts and requiring housing and financial support. Indeed, a decision from the state Supreme Judicial Court in 2017 made it crystal clear that no state law enforcement official has the power to enforce federal immigration law, particularly through the use of detainees lodged by so-called ICE, Immigrations and Customs Enforcement. That case is Lund versus the Commonwealth, 477 Mass. 517. Also, it is beyond dispute that federal preemption occurs from and overrides Massachusetts state laws, including, I suggest, liquor laws, when Congress acts and preempts further regulation in the field. That was the fundamental principle over almost 25 years ago, when the United States Supreme Court struck down a law enacted by the legislature prohibiting investments by the state in Burma. That intruded into the area of federal preemption as it related to international relations, and it was not legal. As applied to federal immigration law, and let's make no mistake, it's crystal clear from the notices of hearing, you are being asked to enforce federal immigration law against a liquor license holder while you have some authority, and in certain instances, it's fairly broad discretion to do so. Your power as liquor commissioners has its source, its root, its derivation through the 21st Amendment of the United States Constitution. That the Supreme Court has said in the case of United States versus North Dakota, the states have core powers to protect public safety, to have an orderly and efficient collection of taxes, and to create and maintain an orderly market in alcoholic beverages. You do not have the authority to enforce federal immigration laws. The ABCC itself has been a named defendant and lost any number of cases in federal court on similar federal preemption issues, whether it's the price discrimination law, whether it is the statutory ban on nude dancing in an establishment that holds a liquor license. There are limits, and the limits are clearly defined. Next, I repeat and reavere my argument for res judicata that is more fully fleshed out in the motion to dismiss. Fifth, I repeat and reavere the statute of limitations argument that was more fully developed in my motion to dismiss. In short, the Woburn License Commission, I think we all acknowledge, no one denies, you took the valuable property of the doghouse and you took the value of the Taste of Brazil for 17 days in January of this year. Contrary to the legal requirements you're supposed to follow under the Fifth Amendment to the United States Constitution. The Woburn License Commission and all those acting in concert with the Woburn License Commission who advised, consulted with you, owe the doghouse and owe the Taste of Brazil compensation. With such flagrant and egregious violations of the clearly established constitutional rights through your improper decision for renewal, you should not exacerbate or otherwise aggravate your own violations of law through your mistaken decisions. Rather, you should mitigate them. The Woburn License Commission today has the opportunity to do so, but if you don't take it today, that opportunity may be lost. Now, you heard Attorney Dickerson say that there's no evidence of mitigation or continued operation. I suggest that's a desperation and a desperate clutch at a straw. It goes without saying that, as Attorney Kelly told you very candidly, as recognized by Commissioner Gilgun, it's an extremely difficult decision to decide to dispose of a case when you really, really, really want to take it to trial. It is torturous. And I think it is fair for the commission to take into account the fact there's no evidence of any prior violations by the doghouse. There's no evidence of any prior violations by Taste of Brazil. And I think this clean record speaks for itself and tells you that this was a case unto itself, a difficult and expensive lesson learned. And I ask you, as you deliberate among yourself, should you find that a violation of some type exists, to keep in mind that justice alone is insufficient and empty. You only act completely when you have justice that is tempered with mercy. Both the Doghouse and the Taste of Brazil have been contributing members to the economic center of Woburn in the downtown on Main Street. I think that should be acknowledged by the Woburn License Commission, in addition to their clean record. And I suggest that if you are inclined to issue a penalty, if you are inclined to find a violation, this is not a revocation case. You can have a huge make-up call and get yourself out from under the 17-day loss of business by having a suspension of the license of the Taste of Brazil and a suspension of the license of the Doghouse for some portion of the 17 days, and consider those days to have already been served back in January. You've done your duty. I can tell you, I can submit to you, that Doghouse and Taste of Brazil will never forget this experience. I'm sure very few of us will ever forget this experience. But you have the opportunity now to take that into account and make a fair and just decision. I'd be happy to answer any questions the chair or any member of the commission may have about my closing. None?
Thank you. Nothing else?
No, that concludes, I think, the hearing from our perspective.
Just one thing from me before I close the hearing is there's been a lot of talk here today, and this is basically for the people in the audience, all right? There's been a lot of talk here today about right to shelter, illegal hotels, sheltering for the homeless, etc. All right? We're the Woburn License Commission, okay? We oversee innkeeper's license, common vic, and liquor licenses. And we have local rules and regulations. And I think I said it once, but, and this, you can look at them on the city website, all right? This board doesn't want to be stuck in the middle of this police officer, that police officer, the federal agents, this, that, all right? We're here for liquor licenses, all right? That's what we're here for. and to make sure the rules and regulations are followed. All right? And and as it pertains to what we're here for, what I thought we were here for, is number 14. No licensee shall permit any disorder, disturbance, or illegality of any kind to take place in or around the licensed premises, including the parking lot areas thereof. Licensees shall also prevent undue noise and disturbance to the adjacent neighborhood. The licensee is responsible therefore, whether present or not. That's important, because that's what we're here for, not migrant shelters and what, I looked through what Governor Healy sent out and Mr. Mayorkas and everything else about, the licensed premises shall be subject to inspection by agents of the Commission, Police Department, Fire Department, and the Board of Health during hours of operation. That's number 21. Number 25, the Commission shall have the authority to impose particular specific conditions on any license, which conditions, if more stringent than their rules and regulations, shall control. The owner and/or manager of record shall be fully responsible for any violations of infractions of the law. These rules and regulations and disorders of disturbances of any kind which take place on the licensed premise, whether or not they are present, including the actions or employees and or entertainers. And last, number 27 is all licenses are subject to suspension, revocation, or forfeiture for breach of any of the conditions, regulations, or any law of the Commonwealth of Massachusetts and or the City of Woburn. That's layman's terms. That's how it is. That's how we're going to vote when we take a vote. We're not going to vote on migrant shelters and pointing people out, specific businesses in Woburn out. We've never done that as a board. Never once. When this stuff first started and they needed a manager of record because they didn't have one, what did we do? We acted quick and we helped them. We help everybody. To insinuate that someone's getting pointed out by this board is disgusting. Disgusting. Take a motion to close the hearing.
Before we do that, Mr. Chairman, I would just like to say that the goings-on at other hotels in the city have nothing to do with this hearing today. And I reject any idea that we are looked at and questioned about the goings-on in other hotels. If something is done wrong and is brought to our attention, we deal with it. And that's the way we've always acted in this commission. I make a motion, we close the hearing.
Anything, David?
No.
The mic.
First of all, I want to thank Attorney Dickerson and Attorney Salvato for all their legal help, and the two attorneys, L.Y. and Y, who did a great job. I probably know Hugo better than anybody in this room. We go back, he probably forgets this, when they were opening up the Taste of Brazil. I was there with an architect named Dominic Sicari, and we helped him set up the Brazilian restaurant. I was so enthralled with this family. This was the American dream come true. Jesus, I was his best supporter. And if somebody told me today that Hugo did that, I'd say, no, you're wrong. You're absolutely wrong. Hugo is above that. But when I see this, signed, sealed, and delivered, admitting that he did it, Jesus, I have no other alternative. Hugo's the only one in downtown business district that has a rooftop dining. Thank you, David. Hugo's the only one that was given 2 pocket licenses. Thank you, David. I led the charge. And as I see a lot of people out there today that I know that are friends of mine and are supporting Hugo, I can understand that. But I can't understand why you raise your right hand to Almighty God that you're telling the truth, and now we get this. Yeah, I did it. I have no alternative. And believe me, attorneys Kelly, L, and EY did a fabulous job. You got a tough case. God bless you.
Motion's made to close the public hearing.
Second.
Motion made in second. All in favor?
Aye.
Aye. Do we want to talk, or do we want to take a vote?
Oh, vote.
Huh?
Let's vote. Let's get it out of the way.
Does anyone have a motion?
I will make a motion, Mr. Chairman. Make a motion to revoke the license and the Taste of Brazil licenses of both the Doghouse and the Taste of Brazil based on the evidence, guilty pleas, and the sentencing of the 2 owners.
Now,
Second?
Attorney Kelly brought up the point, I believe it was, that we have 3 stages. Can close it for 2 weeks or a month or ultimate. So make that in the motion. Make it very plain and clear. No, you made a motion
To revoke.
to revoke, but for how long? Total? The
Indefinitely.
ultimate, then as Mr. Attorney Kelly would say, the ultimate.
The ultimate.
All right, second.
A motion made and been seconded to revoke the 2 to Brazil and the Doghouse liquor license indefinitely.
No, ultimate,
Take a roll.
ultimately.
Roll call.
Commissioner Gilgun,
Yes.
Commissioner McGrath. Yes. Chairman Skeffington.
Yes. Motion passes 3-0. Take a motion to adjourn.
No, Attorney Kelly has the floor.
If I may, I understand that, I'm not trying to intrude into the, I know the vote's been, the motion's been made.
Can you pick your
So-
microphone up just a little bit?
Sorry, I
There
thought
you
it- is that better?
Thank you. That's
Okay.
better.
I recognize the motion has been made, seconded, and the vote is here. As you know, the decision of the License Commission made today is appealable to the ABCC once we get your statement of reasons. I will tell you, it is my plan to file the appeal with the ABCC. In light of that, I would ask whether the Woburn License Commission would agree to stay the effective enforcement of your vote today to revoke the license of Doghouse and Taste of Brazil until we have an appeal hearing and decision from the ABCC on that appeal, subject to it being filed, of course, timely, which is in the next 5 business days.
Counsel? Counsel?
We would agree to stay only for the period of 2 weeks until May 1st. And that
2
should,
weeks?
yeah, that would give Mr. Kelly sufficient time to file his motions with the court.
And no
take
gun to
appropriate-
his head. you know? If there's administrative tie-ups or anything like that, we're not gonna, you know, we're gonna let them.
Make the motion.
I make a motion that we agree to go along with Attorney Kelly, EY, and not put the gun to his head. Put it, 2 weeks is fine if he can do it in 2 weeks. If it takes 2 weeks to 3 days, guess what? That's fine.
Second.
Motion made and seconded. All those in
Aye.
favor?
Clarify the motion, please.
Huh?
To stay,
Clarify.
to stay the
That
motion till
We're
May
going to
1st.
go along with Attorney
Till May 1st?
Kelly's request.
Till May 1st.
So May 1st, okay, so it's not 2 weeks, it's not 2 weeks and 3 days, it's May 1st.
May 1st.
Okay,
Yeah.
thank you,
That's what he asked for.
thank you.
Motion made and been seconded. All those in favor?
Aye.
Aye.
Opposed? Ayes have it, 3-0. Any other matter in front of this board?
Motion to adjourn.
Second.
Motion made to adjourn and seconded. All those in favor? Aye. All those opposed? Ayes have it, 3-0.